Your Lordship,
Yes,
I
please.
beg to mention here in item number 29. Kindly refix this matter after 2 weeks' time, since my
Yes.
senior could not be present today.
You are the counsel for the
Petitioner, sir. Or petitioner, Your Lordship.
on the prayer of Mr. So-and-so. Learned counsel for the appellant. Listed after
2 weeks' time, Your Lordship.
2 weeks on a date to be fixed by the registry.
Please, Your Lordship.
Yes.
My
Mr.
Lord,
Raghul.
I beg to mention item number 36, the last hearing item. In fact, I was going through the petition, the appeal petition on item number 9. That one is a bulky appeal memo. In one go through, you cannot complete it. We need a few days time.
Correct.
It's so bulky. And actually, we are preparing for that one. And because of that, I have not been able to review
That's all right.
my
That's all
appeal.
right. So what is your
may-
prayer?
May I pray that it may be posted after 2 weeks?
After 3 weeks.
Yes.
You are the counsel for the
Appellant.
appellant.
Yes.
Yes, Mr. City. Okay.
Lordship, that is okay, but so far as item 9 is concerned, in item 9, I am the appellant, and in item 36, I am the respondent, and
Yes.
he is the appellant in
Appellant.
that case, the 36, and he is for the respondent in item 9.
Yes.
With great difficulty, I have taken his consent last night to defer the matter for today, item 9. I am deprived of my assisting junior due to some unavoidable circumstances. And moreover, on the last occasion, this honorable court has passed an order, that is on 3rd May, an order was passed directing the CBI counsel to furnish a copy of the affidavit which they have filed. So far, they have not furnished any copy of the affidavit also. So I
Who
have
is
to
for the
go
CBI?
through.
Mr. Gupta?
Yes, my lord.
You're for the CBI?
Yes, my lord. I will furnish.
Your Lordship, last time when the matter was listed in this Arca construction, now by that time we have already received the counter filed by the CBI, and they have nothing to do with
In
the
fact, CBI
matter.
has nothing
It
to
is
say. That is what
not
we
a
find in the
party.
counter.
So that time, the counsel for the CBI submits that the copy of that affidavit will be furnished to the parties
Okay.
before this date.
So furnished today?
Yes, my lord.
Okay. Furnished today.
And Your Lordship, this item.
So let us go one by one. Item 9 first.
Lordship,
Yes.
Okay. Item 9. What is to be done in item 9?
any date.
Your Lordship, in this item number 9,
Whether item 9 and item 36, they are related.
They are not
No, no, no,
connected.
they are not
Lordship.
related.
They are not connected,
related.
but in both the cases, the same counsels are involved.
yes,
Okay,
that is the only
okay.
thing.
And in fact, I wanted to take up item 36 because I'm ready for that.
Okay.
But so far as item 9 is concerned, I'm deprived of my assisting junior.
And actually, I'm ready for item number 9. Because, Your Lordship, the
So
fact
far
is,
as-
the true picture is now there is no state order in this.
Of course, yes.
But because of the obstruction raised by the landowners, the moment the work started, now I cannot continue with the works.
That
And
may be a
because
new
of the
course of
tendency
action.
of this appeal, again, they'll come and obstruct once I start. So there's urgency in this.
So there's no stay.
There is no stay.
There's no stay.
Yes, despite that, I have not been allowed.
So you can always
work.
take the help of the administration.
Your Lordship, they are almost helpless. I have apprised the government also, the department also.
If Mr. City,
So-
if the landowners are depriving the contractor from undertaking the construction, then it is the landowner who suffers loss.
In fact,
That
that is
also is
correct.
true.
But
It is the landowner who suffers loss.
I have no instructions to that effect.
So
Lordship.
if that is the case, and when there is no stay, I think you will have to instruct your client that actually your obstruction of the construction will be your loss, not anyone's.
So far as the sanction is concerned, this honorable court by the ambient order on 29th November 2022 has passed an order that fund meant for this project shall not be diverted for any other purpose.
Correct.
So that is intake. So there is no urgency as
That
such,
is,
and
Your Lordship,
this
the
matter
fund
be
is not
examined.
the issue here.
And
Now, there is a stipulated time for construction of completion of the contract for the works. Now, I have not been able to do that because of the landlord's obstruction. From Kidima side, it was so peaceful. Once I entered into the area of Vistama village, now I cannot continue further. And this appeal, in fact, is a proxy petition. Although they have taken the name of the contractor, RK Construction, he is not interested. In fact, the petitions will show that the landowners are fighting on behalf of the contractor. Otherwise, the contractor has
is
never
also
filed any
indebted as a
affidavit.
party.
Mr. CT, we would request you to actually take up the matter with the landowner, since there is no stay to the order passed by the single judge. So
Yes.
at least, I think the respondents should be allowed to continue with the work.
Yes, Your Lordship.
Let the state respondent also respond to this.
Who is for the state?
So far as I'm concerned, I have no instruction to that effect. And if at all there is any such incident, then that is a fresh cause of action. They can resort to any means, Lordship.
Who is for the state?
Empty Imsong.
Where is MT Imsong? Yes. Where is he? Because actually some serious concern has been raised. So it is for the government to actually settle all those things. Where is additional AG?
Lordship, I'll intimate to him, Your Lordship, what the.
Not intimate. We want some. We want to put some queries.
Okay, Lordship, Kiri has gone out to call him, Your Lordship. So the meeting adjourned for somewhere.
Revisit. We'll list after some time.
Okay, Lordship.
We'll hear the government also on the issue raised by you.
Your Lordship.
We'll hear the government also.
Item number 36, let it be after 2 weeks.
Lordship, in this case, there are vacancies. But then, in view of the pendency of this appeal, the cases for promotion could not be considered. So there is urgency here.
There are many seniors above them, above the respondents. In this, they are the respondents. So
Okay.
they are not within the zone of promotion, even if there is a vacancy. So they will not be deprived
Okay,
of any
Mr.
rights.
City, since Mr. Iralu has expressed some difficulties, let us accommodate him.
I'm also expressing my difficulties in my item, Lordship,
In which item?
item 9.
Yes, that we said we will revisit.
Lordship.
Yes.
In item 36. Mr. Iralu, why don't you make it 2 weeks instead of 3 weeks?
All right.
Mr. Iralu, the learned senior counsel for the appellant, submits that he needs to go through the file and therefore seeks for 2 weeks' time. Prayer is allowed, listed after 2 weeks.
Oblige your lordships.
May I please, my lordship? My lordship, I beg to mention item number 8. Kindly grant us 2 weeks to file affidavit in reply filed by respondent number 5 to 74.
5 to 74.
Yes, my lordship.
You are the counsel for the appellant?
Yes,
for
my
the writ
lordship.
petitioner?
Yes, my lordship.
Item 8.
Yes, my lordship.
Mr. So-and-so, the learned counsel for the petitioner, submits that he may be allowed 2 weeks' time to file affidavit in reply to the affidavit in opposition filed by the respondent number 5 to 74. Prayer is allowed, listed after 2 weeks.
Much obliged.
For motion, item 1, read appeal 5, 2023.
Your Lordship,
Yes.
the writ petitioner, he was appointed as a clerk in State Bank of India in 1991. Your Lordship, since 2006, he was on unauthorized leave,
Yes.
and he remains absent from duty without submission of any applications for leave or proper sanction of leave since 10/10/2006. Whereupon he was issued 3 notice, white memorandum dated 3/11/2006, 4/12/2006, and 5/10/2007, calling upon to report for duty within a specified period of 30 days mentioned therein. Your Lordship, the writ petitioner did not report on duty in response to the said notices, and accordingly, his name was struck off from the rolls of the establishment, deeming that he had no intent to work for the bank, and leading to voluntarily cessation of his employment with effect from 10/10/2006. That is from the date he was remained absent from the 10/10/2006.
2006.
Yes, Lordship.
Since then, he has remained absent.
Yes, Lordship. So we have issued 3 notices calling him to join the duty. However, he he preferred not to work for the banks, and accordingly, in 2009, his name was struck off from the rolls of the establishment. Your Lordship, he have accepted his voluntary cessations, and accordingly, in 2011, he wrote a letter for his provident, for the release of his provident fund. Again, in 2012, he wrote a letter for release of his gratuity benefit. Now, only in the year 2014, Your Lordship, he wrote one representation for invalid pensions.
What is the procedure followed to allow a person to go on pension? What is the procedure followed?
Your Lordship, there is a rules to State Bank Employees Provident Funds rules, and as per 22, a person should serve 20 years or above. Your Lordship, and if he go for the medical on ground of medical ground, if he retires, then it is 10 years and above. However, in the instant case, Your Lordship, he was voluntarily ceased from the employment.
What was the direction of the single bench?
Your Lordship, the direction to constitute one medical board.
So what is wrong in that?
But Your Lordship, he have never challenged his voluntary cessation. He has never challenged his voluntary cessation, Your Lordship.
But the direction given by the learned single judge is as per the rules.
No, Your Lordship.
Medical board.
No, Your Lordship, since his retirement was not on the medical ground, Your Lordship.
His retirement was not on medical ground.
He is not.
He was actually released on cessation of work.
Lordship.
But this court had, as per the rules, directed a medical board to be constituted.
Your Lordship, if he is retired on medical ground, then only the medical board will be constituted, Your Lordship.
Whether the bank has taken recourse to that?
Yes, Lord.
Whether the bank has taken recourse to that by referring his case to the medical board?
No, Lordship.
Mr. YP Gupta, learned counsel for the appellant.
Your Lordship, as per the rules, his retirement.
This appeal has been filed.
His
Against-
retirement is ruled by
The order dated 27/3/2023 passed by the learned single judge in WPC number 117K/2019. Stop. The appeal is admitted. Issue notice to the respondents, returnable within 4 weeks. The learned counsel for the appellant shall take steps for service of notice to the respondent number 1 and 2 by registered post with AD within a period of
3 days.
3 days from today.
Your Lordship, I have also filed one stay of operation of that informed order. Lordship.
Mr. So-and-so, learned counsel for the applicant. By this application, the applicant has prayed for staying the operation of the impugned order dated 27/3/2023, passed by the learned single judge in WPC 117K 2019. Issue notice to the respondents, returnable within 4 weeks. The learned counsel for the applicant shall take steps for service of notice upon the respondent number, upon the opposite parties / respondent number 1 and 2 by registered post with AD within a period of
3 days.
3 days. Okay.
Obliged, Your Lordship.
Item 2, ISC Book 31, 2023.
My best Lordships,
Yes.
the present I has been filed for the continuation of delay, Your Lordship. There's 26 days in filing the review petition 1 of 2023, Your Lordship.
Who is for the respondent?
Lordship, I'm representing respondent number 2 and 4, Lordship.
2 and
4, Lordship.
that means opposite
Department of-
party 2 and 4.
Yes, Lordship. Department of Horticulture, Lordship. Lordship, in the I have no objection, Lordship.
1 and 3? Yes, sir. Yes. Any objection? No. But where have you stated the grounds for the delay? Where have you stated? I don't find any grounds.
Yes, Your Lordship.
You read the whole petition. We
Yes,
don't
Lord.
find any grounds.
Yes, in Bharat only I've stated that regarding the delay only, but then
Yeah, you read your para too.
that the civil review petition 1 of 2023 ought to have been filed within 1 month, that is on or before 15/12 of 2022. However, the applicants are before this honorable court after a delay of 96 days.
So that is not a ground.
Yes, Lord.
That is not a ground.
But Your Lordship, in a review, there is no specific provision for the filing of delay, Your Lordship.
But the statutory period of limitation applies
Yes, very
in
much.
principle. You pay cost to the bar. Okay, you pay a small cost to the bar.
Yes, Lord.
You have not cited any reasons.
Yes, Lord.
So we are allowing, since there's no objection also, but you pay a small cost to the bar. In view of the fact that you have not cited any reasons.
Yes, Lordship.
Okay,
Yes, Lord.
we impose a cost of 2,000, small.
Yes, Lord.
Mr. Subungwati.
Yes, Lord.
Mr. Subungwati, the learned counsel for the applicant. And Mr. Muajamir, Muaimchen for the learned senior government advocate for the respondent number 1 and 3. Stop also heard Mr.
Lordship.
Muajamir,
Mojame, Lordship.
the learned counsel for the respondent number
2 and 4, Lordship.
2 and 4. Stop. This is an application filed under Section 5 of the Limitation Act 1963, praying for condoning the delay of 96 days for filing the connected review petition. both the learned counsel for the respondent number 1 and 3 and for the respondent number 2 and 4 has no objection to the application filed for condoning the delay. The delay of 96 days is accordingly condoned on the condition that the applicant pays a cost of rupees 2,000. Stop. The cost imposed shall be paid in favor of the High Court, High Court Bar Association, Kohima bench. Stop. The application stands disposed. You pay
Yes,
a
Lordship.
small amount, okay? Yes. Now what is this review?
Yes, Lordship. Case current,
Any objection to be filed? Any objection?
This can be listed for hearing, Lordship, for review, Lordship.
Your Lordship,
What is your ground for review?
Your Lordship, my only ground is that the government of Nagaland has adopted the CCS pension of 1972.
The
CCS pension rules 1972, saying that it is applicable to the state government employees, Your Lordship. So, Rule 2 says that if a particular state government is served,
that was not the ground in your writ petition.
no, it was there, Your Lordship.
Was it a ground in your writ petition?
Yes, Lordship. But then in the appeal petition, I failed to submit before the Honorable Court, Your Lordship.
So when actually the appeal does not bear that ground, you are actually filing a review for reviewing the order passed by the Honorable Division Bench.
Yes, Lordship.
So when that ground has not been set up, how do we actually entertain your petition? Anyhow, we'll actually list it for hearing. We'll list it for hearing, okay?
Lordship.
Lordship, notice may be issued, Your Lordship. Notice yet to be issued, Your Lordship.
Since both are represented,
Yes, Lordship. I'll serve in the course of the day, Your Lordship.
yes. Heard Mr. Subhamwati, the learned counsel for the petitioners. Stop. Also heard Mr. Moimchan, the learned senior government advocate for the respondent number 1 and 2. And Mr. Jamir, the learned counsel for the respondent number 2 and 4. The learned counsel for the applicant, for the petitioner, shall serve the requisite copies of the review petition to the learned counsel for the respondents within a period of,
In the course of the day, Your Lordship.
in the course of the day, listed for hearing after 2 weeks.
Lordship.
Obliged, Lordship.
For admission, item 3, PIL for 2020.
May it please, my lord. My lord, I may be given a week's time to file my affidavit, my lord.
Okay. Affidavit to what, Mr. Santi?
My lord, by this honorable court's order, my lord, I was directed to file an affidavit, my lord.
By which order?
It's not mentioned in my file notings, my lord, but my lord, I have called the petitioners, my lord. Since they are from a remote area of Nagaland, in Kamale area, my lord, they'll be reaching tomorrow. And after that,
Okay.
I'll be filing the affidavit, my lord. The affidavits are ready, my lord.
Affidavit in regard to,
In regard to what work have been executed, what is pending, and
and that was by which order? At least we can make a reference to the order.
3/5/2023, my lord.
3/5.
2023.
2023.
my lord.
No, nothing is mentioned. As prayed for, listed after 2 weeks.
Lordship, but the order has been passed, my lord, which is why
I know. But what is that order?
I have drafted that affidavit, my lord.
Twenty-two three. 2023.
Yes.
22-3.
22/3/2023, my lord. Noting the
22-3-20.
pass course.
22. What is the, you were also supposed to file an affidavit?
Your Lordship, as directed by this Honorable Court on 22nd March 2023, action has been initiated
What action?
upon the respondent number 11
What action?
by imposing 1 year withholding 1 year annual increment.
Have you
Okay,
filed
to-
affidavit, Mr. LT? Have you filed
On-
affidavit?
Your Lordship, on 26 April 2023, we have produced the action taken report,
You please file an affidavit,
my lord.
okay?
It is in the
In
report.
closing,
I placed before this Honorable Court on 24th, 26th for 2023, Your Lordship.
what was the action taken? Now therefore, on the recommendation of the governor,
Gitu ko yun na. Photo pass. 22 ano?
what was the affidavit you were supposed to file as per the order dated 22-3-2023? What was the affidavit you were supposed to file?
What action has to be initiated against
So you
the
file an affidavit. There is an order from the court.
last occasion?
You file an order, you file an affidavit.
Much of-
You file an affidavit,
Your
okay? You file an affidavit. In terms of the order dated 22-3-2023. Mr. Sentianger, the learned counsel for the
Petitioners.
petitioner, 6 for a week's time to file the required affidavit. Stop. Mr. LT Sanctum, the learned additional AG, shall also file an affidavit enclosing the memorandum dated 25/4/2023 issued by the Commissioner and Secretary to the Government of Nagaland, Works and Housing Department. Listed on
After a week, my lord. On 24th,
24th.
my lord.
Yes, Mr. LT.
I may
Okay.
be granted 2 weeks' time, Your Lordship.
Okay.
2 weeks' time.
First, my lord.
31st.
My lord.
Listed on 31/5/2023.
Oblige, my lord.
Much obliged.
May I please, Your Lordship?
Yes.
With the leave of Your Lordship, I beg to mention item number 9. Your Lordship, here, I have been pre-engaged with some officials regarding a very sensitive issues. So the matter will be listed on next step, next TV.
No, Mr. MT, what we want to know is that actually by the order passed by the learned single judge, the respondents are allowed to continue, are allowed to work. But we have a submission from the learned council stating that actually he has been obstructed by the villagers, which is the petitioner appellant number 1 to 1 to 79. So I think it is now for the state government to take action against those who are obstructing. That is why we required your presence, not for any other.
But so far, we have not received any complaint.
Just check up,
Okay, I'll take the
just check
instruction.
up, and then if there is any obstruction, I think that should not be allowed. That should not be allowed.
Your Lordship.
Because any work within the village jurisdiction will only benefit the villagers, not anybody.
Definitely.
So you kindly see to it. You
Definitely.
kindly just make some inquiries from the district administration.
Lordship.
Yes, where is that file? Item 9.
Your Lordship, my submissions on the interference by the obstructions.
Yes, yes. Please come near the mic.
My submissions regarding the obstructions raised by the villagers may be reflected in the order. Although I have not made any complaint to the administrative side, I have reported to the department for assistance, but they are helpless.
Mr. City Jamir, learned senior counsel for the appellant assisted by
Aliba Ozakam.
so and so. And Mr. R. Iralu, the learned senior counsel, assisted by Mr. L. Iralu for the
Sole respondent, private respondent,
respondent number
private respondent number 4.
for the respondent number 4. Mr. Imti Imsong, the learned additional advocate general, appears for the respondent number. For the respondent number
1 to 3.
1 to 3.
1, 2, and 3. Stop. Today, when the matter is taken up, Mr. Iralu, the learned senior counsel for the respondent number 4, submits that. the writ petition. Number WPC 140/2022, filed by the present appellant as the petitioners, was dismissed by the learned single judge by order dated 29/11/2022. However, in spite of the order passed by the learned single judge, it is submitted that the appellant petitioner number 1 to 79 are obstructing the respondent number 4 in carrying out the construction of the road within their village jurisdiction.
Yes.
Stop. Mr. Imti Imsong, the learned additional advocate general, Nagaland, shall take up the matter with the district administration, PEC,
No, Kohima.
with the district administration. Kindly take up the matter, Kohima. And submit a report to that effect on the next date fixed. Listed on
Next Wednesday. This will be.
My lord, my learned friend has made a submission that they have not filed any complaint to any authority.
No, to the administrative
That is-
authorities.
Oh, we will just ask our learned senior additionally, this additional advocate general to verify.
Let
Proceed.
the additional advocate general verify from the department also, because the work is executed by the PWD department. So
Okay,
let
what
him
was the
take up-
last line? What was the last two, 3 lines? Session as well as with the department concerned and submit the report to this effect on the next date fixed. Okay. Listed on?
24.
Okay.
Your Lordship, I'm appealing for respondent number 5.
Okay. Mr. YP Gupta appears for the respondent number 5. Listed on 24? Okay. 24/5/2023.
Item 4, Criminal Appeal 3, 2022.
This is item?
May I please, your lordships?
Yes.
I'm mentioning on behalf of the National Investigation Agency, lordship. Now here, the special PP who is engaged for this matter, his engagement period has been over, lordship, and the new is yet to come. So,
Ms. Apila,
lordship,
since when have you making that submission? It's a long time
lordship,
back.
but it's still on the process of engaging the new
No, that's okay.
lordship.
Because actually, without the appointment, the NIA cannot file the rejoinder.
Lordship, agree to that, lordship.
But I think next time you should come up with a better excuse
Lordship,
than with this.
lordship,
Okay.
lordship. 3 weeks, lordship.
3 weeks will actually like. Are you the counsel
No,
for
no.
the NIA also?
No, lordship, no. I'm just mentioning on behalf, lordship. Since
Mentioning
the
on behalf of?
the agency,
Oh.
lordship. The special PP, Mr. N.N. Mishra's engagement is over, lordship.
You were asked to mention, but you are not appointed.
No, lordship, no, not yet,
That's not fair.
Lordship.
That's not fair.
lordship.
MS Apila. The Learned Council makes a submission on behalf
Yeah.
of the appellant. And submits that since the appellant is in the process of appointing a new standing counsel, 3 weeks' time may be
Lordship.
granted to the appellant
Lordship.
for prosecuting the case. Yes, MS so-and-so appears for the respondent/accused. Listed after 3 weeks on a date to be fixed by the registry.
Lordship, similar prayer for item number 5 and 6 as well.
Item number, okay, similar prayer for item 5 and 6.
Item 7.
Obliged, Lordship.
Read Appeal 38, 2022.
Notice, Lordship.
Yes,
Lordship, this is an appeal against the impugned order dated 10/8/2022 passed by this honorable court, where this honorable court has directed the respondent to pay the same scale of pay as was given to the other colleagues of the petitioner. Lordship, I may be allowed to take you to.
we'll list it for hearing.
Lordship.
Okay.
Lordship.
We'll list it for hearing. For admission hearing?
Lordship,
When?
at the convenience of this honorable court, Lordship.
No, at your convenience.
Next
Lordship,
week, then?
after 3 weeks, Your Lordship. After no. Okay.
Okay. Okay. On the prayer of the learned counsel for the parties, listed for admission hearing after 3 weeks. Okay?
Lordship,
Much.
much obliged.
For orders, RFA 2, 2019. Item number 10.
Yes, Mr. Gupta.
Your Lordship, I am the respondent in this case, Your Lordship. On the last occasion, the appellant's counsel have withdrawn their wakalatnama.
This is the problem. Where is Mr. Fuseko? Mr. Fuseko is not around. He is required for this case. So Mr. Gupta, you kindly see the order dated 15/2/2023. 15/2/2023. The letter dated 18/11/2022, which is the retirement notice, shall be considered on the next date. Thereafter, we have not passed any order on this. Yes, Mr. Fuseko,
Lordship.
this court needs your help.
Yes, Lordship.
On 15/2/2023, correct? we had passed an order stating that the letter dated 18/11/2022, which is the retirement notice submitted by you,
Lordship.
shall be considered on the next date. Correct?
Lordship.
Thereafter, we have not passed any order.
Lordship.
So, I think verbally I have requested you to contact that person.
Yes, I've contacted.
So,
They said that they will arrange some other advocate. So today, but I see that today they have not made any arrangements.
but I feel that you don't have a case also. That person doesn't have any case. He has to contest before the DRT, Gauhati.
Lordship.
But
But
since
since I'm no more the council, I cannot make any submissions in that, Lordship. But since Lordship on Lordship, because I've contacted them, I've even sent them the today's list
okay,
in advance. And I've told them to make arrangement. They didn't reply. But on the last day when I contacted them, they said that they'll make arrangements. But till date, they have not made arrangements. So Lordship maybe for the studies, maybe pause it for another day. Then the next
Yes,
day, if they don't appear, Lordship may pass a bit orders.
where is that retirement letter? 18. Mr. Fuseko, the learned counsel, submits that in terms of the retirement letter dated 18/11/2022, which is recorded in the order passed by this court on 15/2/2022. Mr. A.K. Rai, advocate, and his associates, which also includes Mr. Fuseko as the learned counsel, are no more representing the appellant. Correct? Stop. Mr. Fuseko further submits that consequent to the order dated 15/2/2023, he had personally conveyed about the retirement. He had personally conveyed to the appellants about the retirement of his lawyers, about the retirement of his counsels representing him from the case. The stop. Let notice be issued to the appellant appellants, okay? Notice be issued to the appellants. Through the, which police station? Purana Bazar?
East, sir.
East Police Station, Dimapur?
Yes, Your Honor.
Through the officer in charge of East Police Station, Dimapur. who shall thereafter file a report stating service of notice upon the appellants. Stop. The registry to take steps. Listed after?
4 week, my lord.
Listed after 4 weeks. Okay.
My, your lordship, my presence may be
Yes,
soon.
Mr. So-and-so, YP Gupta appears for all
3, 4, and 5.
appears for the respondent number 3, 4, and 5.
Oblige,
Item
your
number
lordship.
11 and 12. Criminal Appeal Jail 10, 2022.
Yes,
My lord. The LCRs were called, my lords, on the day of motion, my lord.
part file. What do you mean part file of GR? That means actually the incomplete file is not received.
No, my lord.
The office note shows that
Yes.
the registry has since received a part file of GR
Yes, my lord.
27, 2003 from the court below along with the forwarding letter.
Yes, my lord.
Why
appears-
part file?
It appears there is some difficulty locating the LCRs, my lord. It's an old case, my lord, and there was a shifting of the district court complex in Peck district, and that's how it appears the LCRs, some of the LCRs got lost. And that is how, my lord, I was also unable to obtain a copy of the CDC copy of the impugned judgment and order, my lord, as well as the FIRs and the confessional statements, if there is any, and the statements and the depositions, my lord. Now, my lord, the impugned judgment and order, I was able to obtain only from the jail authorities because the jailer, he keeps a record, a copy of the judgment, of the conviction order, my lord. So that's how I obtained it and then annexed it, my lord, in the instant petition. Which is why, my lord, I have apprised this honorable, because efforts have been made, my lord, to obtain CTC of the LCRs, my lord, through paralegal volunteers and panel lawyers of the legal services authority under Peck district, my lord, but they were unable to, my lord. And that is how, my lord, the complainant, my lord, has also not been impleaded, which is why on the day of motion, this honorable court has passed an order that, my lord, if the LCRs are called and if the complainant is known from the LCRs, then liberty has been given, my lord, to implead.
Mr. Santi,
My lord,
losing record is not a good thing.
my lord, my lord, my lord.
So we may have to direct the district judge to make more efforts.
My lord,
If not, we will have to call for explanation.
my lord, my lord, my lord, in 2004, 4 SCC, page 6, my lord, similar case has, ground has been, issue has been raised before the Honorable Supreme Court. The Supreme Court directed for reconstruction of the LCRs, my lord, and to the best possible ability, it will be done. But if it is unable to be reconstructed, then the benefit must be given to the accused.
You are supporting the ruling which is in support of your case. You are citing a ruling which is in support of your case.
But Supreme Court,
But,
my lord,
but
yes.
of course,
Yes, my
let
lord.
us make all efforts
My lord, my
to
lord,
see that the records are traced.
my lord, my lord.
Okay.
My lord.
And if not, then we cannot lightly let the officer also go. At least we will have to, maybe we will have to ask him to give explanation
On that,
as
my
to how
lord,
the records got lost.
On that, my lord, I
Then maybe even the previous officer,
my lord,
who
I
was
make no
there?
comments, my lord. On that, I cannot.
Because
Make,
losing record,
my lord,
I think that only shows very carelessness.
my lord, my lord.
And we cannot allow that to happen.
Yes, my lord. The appellant, he has been in prison for more than 20 years now. Since the initial date of his arrest, he has been under
He is
custody.
convicted under what?
376 and 302, my lord.
That is also bad again.
Yes, my lords. My lords. And I am before this honorable court particularly.
376, 302.
Yes, my lord. I am particularly here before this honorable court challenging the conviction under 376, my lord. My contention in the criminal appeal is that, my lord.
You cannot rape a dead person.
Yes, my lord. Substantial law, my lord, has been misinterpreted and misconceived. Consent, my lord, becomes impossible to be obtained. Now, my lord, under Chapter 17, my lord, under Section 404, the property of a dead person has been protected, my lord. But the framers of the Indian Penal Code, my lord, the legislators in their wisdom, my lord, under Chapter 16, no such protection has been given of the human body, my lord. And the law,
But we have also come across cases
yes, my lord.
where some inhuman persons,
Yes, my lord.
they murder
My lord.
and then thereafter they commit rape.
Yes, my lord.
We have come across such persons.
Yes, my lord. Which is-
Hopefully, maybe this person is not one of that.
No, my lord.
But,
My lord. And my lord, there has been cases in India, my lord, as well as in abroad also, my lord. This kind of incidents are called necrophilia, my lord. So there has also been some suggestions to penalize, my lord, make it a crime, this particular act, my lord. But till date, and not particularly under 376, the the definition, my lord, given under 375, it does not encompass, my lord, the
it does not include such
yes,
persons.
my lord, my lord, my lord.
Okay, brother. So we give some opportunity to the district judge to make an effort again.
My lord,
Okay?
my lord, my lord.
And only thereafter, as my brother has suggested, we may go for reconstruction of the files.
My lord, my lord,
Okay?
my lord.
Mr. Santianger, the learned counsel for the appellant, and Mr. Kiangami, the learned public prosecutor for the state respondents. Stop. We have seen the office note dated 24/4/2023. Wherein it is reflected that only a part file of the keys, namely GR 27/2003, has been received from the court below. We have also perused the letter dated 12/4/2023, written by the learned district and session judge, Peg Nagaland, to the Register, Guwahati High Court, Kohima Bench. Nagaland, Nagaland, Kohima. On perusal of the office note dated 24/4/2023 and the letter dated 12/4/2023, we are of the view that more opportunity should be given to the learned district and session judge Peck to properly search and trace out the full file of the GR case number 27/2003. Stop. The learned district and session judge Peck, after carrying out the exercise, shall submit a report to that effect on or before. Yes, when can we give the date? On or before?
3 weeks, my lord. 7th June, my lord. 3 weeks will be after.
3 weeks will be on or
7 June.
before? 7.
Yes, my lord.
7/6/2023. Listed on
My lord, if can be 6.
on or
Six,
before? Okay.
yes, my lord. So that
Let's
will
make
be
it
listed on-
5.
My lord.
5/6/2023. Listed on 7/6
my lord, my lord.
2023. Okay.
Obliged, my lord. Now, my lord, in the bail application, my lord.
The bail application.
Yes, my lord. An order was passed, my lord,
What was the order passed?
on 22/3/2023, my lord. Here, my lord, the registry was given certain direction and to put up a note as to whether, my lord, it should be titled as a bail application or as an interlocutory application. It appears, my lord, the registry has already put up a note, my
What
lord.
is? So bail application.
Yes, my lord.
So you are right.
My lord.
You file this bail application.
My lord, as bail application, my
So
lord.
registry also says that it should be registered. Oh, it is appointed bail application
Yes, my lord.
ought to be registered as IA.
Yes, my lord. Aye. Therefore, my lord, the note put up by the registry, my lord, it may kindly be reflected in today's order, my lord, so that in other cases also, the order passed today in this case can be used, my lord, can be referred to. Because in item 14 also, my lord, similar orders may
Okay.
be required to be passed, my lord.
So I think if that is the order to be passed,
My lord.
then you also need to make necessary corrections with the application.
My lord. If, yes, permission is given, my
Yes,
lord.
yes.
Yes, my lord.
Oh. Okay. They're saying that since your bail application has gone into the system,
My lord,
it will not be, unless you withdraw it
my lord,
and then file a fresh application, it will not be possible for them to make any rectification.
my lord, my lord.
We will order accordingly. You make just because it will be only, I think, with the change in the nomenclature.
My lord, then in that case, my lord, without elaborating, my lord, I may be allowed to withdraw the bail application, my lord. And then I'll file afresh.
Mr. Sentianger, the learned counsel for the applicant, submits that he may be allowed to withdraw the application with liberty to file afresh. Stop. Prayer is allowed with liberty to file afresh. Mr. Kiangami, the learned PP, appears for the state respondents. Okay.
Deeply
I think
obliged,
that
my
will
lord.
be more convenient for
My
us.
lord, my lord.
Item number 13 and 14. IA Criminal 21, 2022.
My lord, in item 13, my lord, I have taken steps, my lord. I may be given 2 weeks, my lord, to file my affidavit, my lord.
Item 13.
Yes, my lord.
Item
Upon the
13 is
complainant.
21.
Yes, that is the respondent number 2, my lord.
What steps you were supposed to take?
Through
Mr.
the
Setiam?
officer in charge, my lord, I was required to serve notice, my lord, upon the respondent number 2. So that process has already been completed, my lord. So the receipt they'll be sending, my lord, within the course of the week. After that, I'll be filing affidavit, my lord.
Step has been taken.
Yes, my lord.
Step has been
My
taken.
lord, my lord.
Why don't you also file an affidavit to that effect?
My lord, that's why, my lord, I may be given 2 weeks, my lord.
Mr. Sintianger, the learned counsel for the petitioner, applicant, for the learned counsel for the applicant, shall file affidavit on the steps taken effecting service of notice upon the respondent number 2,
My lord.
listed on,
After 2 weeks, my lord.
listed after 2 weeks. Okay.
Now, my lord, in item 14.
Same
similar
issue.
problem- Yes, same issue, my
Same
lord.
order, bail
Yes, my lord.
application, same order.
Deeply obliged, my lord.
Item number 15 to 25. Read April 26, 2022.
May I please, Lordship?
Yes,
Lordship, in item 15,
in item,
Your Lordship,
ah.
I am appearing for the state. I've been engaged by the state to appear. I have filed my Bakalat number.
Okay.
Though in the cause list, my name is not reflected. Lordship, I am not appearing in this case as government advocate, Your Lordship.
okay, item 15.
Item 15, Your
You are
Lordship.
appearing for the state respondents, but as an engaged counsel.
Lordship, I have filed my Bakalat number also.
Oh.
The only thing is that my name is not reflected. Now, Your Lordship, there are other analogous matter. Item 15 to 25, Your Lordship. There are other 10 other matters are listed as analogous, Your Lordship, because all the matter relates to regularization of service and for grant of pensioner benefit, Your Lordship. And that is why all these matters are clubbed together as analogous. But, Your Lordship, the facts and the issue involved in all the cases, I'm sure will be different.
We are trying to bring in the Honorable Supreme Court's order and clubbing all this together.
Lord,
But maybe the fact situation, maybe I think we also made a mistake. directing to club all this.
Lordship, in fact, in the last occasion, I objected to the
No.
clubbing of this matter because factually cases are different.
So,
Though the end result will be the same, but factually it's different, Lordship.
so in my respectful submission, Your Lordship, like whether all this analogous matter can be disposed of by a common judgment order, that aspect of matter, I leave it to Your Lordship to examine.
No, because actually, if it is to be disposed by a common judgment, then we have to see all the facts. And if the facts are different, then
Yes.
it will not be possible to dispose the cases by a common judgment.
Lordship. Now,
But we have actually. Say what if we segregate the cases but list the cases on the same day? Mr. TV?
I have no objection, Your Lordship, because I am appearing only in 15. I have no objection, whichever way, Your Lordship. If Your Lordship want to hear the matter together, club.
No, that's. I
maybe,
think that is what I feel also, because though there was a direction to club all these cases together,
Lordship.
that was on the basis of the judgment passed by the Honorable Supreme Court.
Lordship.
But I think during that time when we actually directed to list all this club together, I think we did not foresee all this, that there may be different facts and circumstances in each case.
Lordship is correct.
So each case has to be dealt with on its own facts and circumstances.
Yes,
Lordship.
So what do we do now? Yes, Mr. MT?
Mine
We-
is, my lord, 30. 30.
You are 30?
Yes.
Oh, you are not in this 15 to 25? You are not in this 15 to 25?
No.
You are not?
15 to 20. But in here, maybe in batch,
It is a continuation. Look slide.
15, 25.
Oh.
Item 26 is different.
26 is different, yes, Lordship.
Then 20.
From item 30, again, another batch starts.
Otherwise, it's more or less the same.
Again, it starts from item 29.
Item 30,
Item
31.
30.
36.
30 to 36, yes.
Item 30 to 36, is it? No.
So,
No, 30 to 35.
So what will be the best way? We segregate,
Lordship.
and we fix all the cases on the same day.
Lordship.
We segregate, but fix the case on the same day.
Lordship.
Same issues.
Lordship, if, in that case, if 15 can be taken up and the other can be released.
No.
If 15 can be taken up today, Lordship.
Okay. 15.
Yes, Lordship. Because the matter is ready for hearing, Lordship. 15. If the item number 16 to 25 can be segregated, Lordship, and if item 15
Oh,
can be taken
yes,
up.
Lordship can hear 15 and the rest next week, whatever can, Lordship can see. That can be
My
done.
Lord, I am appearing for the respondent in item 25, my Lord. I also want my case to be segregated, my Lord.
That is
Yes.
unless some cases are similarly circumstanced.
I
with
think
the-
item 16 to 24 might come in the same line with item 15. As per what,
And so that, I'm not sure.
because
but
they have completed their years of service, Lordship. They retired on supination. And mine also, in item 15, I have retired from supination after supination, Lordship, and then I am claiming for pensioner benefit because I have completed my service. So 16 to same line here as well. 15 to 24. I think same line. 15 to 24.
Amin aja nih, betul soal.
So in that matter, if 15 can be disposed, Lordship, with the 16 to 24 may be covered. Either way, Lordship. As far as 20,
Who is for item 16
My lord.
and 17?
17,
Yes, my lord.
up to?
Up to 24.
17 up to 24, Mr. Likase.
Yes, my lord.
It's your
16,
case.
16 to 24. Yes.
16 to 25. Who is 25?
20.
25
Okay, okay.
Yes.
Uh, Mr. N. Muzui, the learned counsel for the appellant.
No, the respondent, Lord.
Here, state is the appellant.
State is the appellant.
Oh, the learned, I'm sorry. Mr. T.B. Jamir, the learned counsel for the appellants.
No, in item 15.
And Mr. N. Muzui
Lordship.
for the
Sole respondent.
respondents in WPC, in WA 26/2022.
Lordship.
Stop. No, stop. And Mr. Likase. You're for the appellant.
No,
No. And for the,
appearing for state respondent.
16 to 25.
Yes, my lord. 16 to 24.
16 to 24. And Mr. E. Thibapong, the learned government advocate for the state appellants in
WA 16 to 24.
item number, which is the read petition will be in item number
16 to 24.
16 to 24.
Yes.
And writ appeal also 16 to 24.
16 to 24. And Mr. Likase, I'm coming for the respondents. Also heard Mr. M.S. V. Sokre, the learned additional advocate general for the state appellants in item 25. And
Santiago, my lord.
Mr. Sintianger, the
For the
learned
sole
counsel
respondent.
for the
Sole respondent.
respondents. Stop. It is submitted by the learned counsel for the parties. That taking up all the cases as analogous matters may not be proper, since the facts and the circumstances in all the cases may differ case-wise. And in that view of the matter, the learned counsel for the parties are of the view that it will be more appropriate to segregate the cases and to hear the writ appeals individually. Stop. This court is also of the view that the facts and circumstances in The present writ appeals may differ from case to case, and it may not be appropriate to deal with all the matters as analogous. Stop. In that view of the matter, all the writ appeals listed in item 15 to 25 shall be segregated and listed accordingly. The registry to take necessary steps. Okay. So 15 to 25, we are segregating.
My lord.
Okay?
My lord.
It will
Item
be listed
25.
as individual writ appeals.
My lord. Item 25 may be listed after 2 weeks, my lord. In that case. Because 2 weeks then.
Any other mention?
No, my lord.
No, the other councils?
Lordship, whether it will be possible to take up item 15 next witness, Your Lordship?
Yes, very much.
Lordship, I will highly obliged.
Lordship,
If it can fix on 24th.
if it can be taken up today, Lordship, because it's a short matter. It's a very short matter, Lordship. Now,
No.
whether I'm entitled for pensioner benefit, Lordship. Okay, Lordship. On 24.
To 24th, Your Lordship.
Next week.
List, this will be list WA 26/2022 on 24/5/2023.
Obliged.
Others?
Obliged.
My lord,
Obliged.
item number 16 to 24, let the matter become after 2 weeks, my lord.
Okay.
Then, my lord, next week, 24.
Okay, Kiwi, item number, let me not write all this W. Item number 16 to 24.
Yes.
After, on?
Next week, 24. Date
On
24, 5, yes.
5/2023.
Lordship.
Then, Mr. Santi,
After 2 weeks, my lord.
item number 25.
Yes, my lord.
After 2 weeks, as prayed by the learned councils, as prayed for by the learned councils. Okay.
Deeply obliged.
Item 26, 27, and 28. WPC 261, 2021.
Yes, Mr. Tongpong.
May it please your lordships. I am impugning the Nagaland Employment and Craftsmen Training Service and Nagaland Subordinate Employment and Craftsmen Training Service Rules of 1998, your lordship. Before going into the facts of the case, your lordship, I would like to take your lordship to the
You are referring to which? 26 WPC
Yes.
261.
yes.
And with WPC 351 with 170. There are 3 writ petitions. 3
Yes.
writ petitions.
2 are filed by me. Your lordship, one is 351.
Yes, we will take 3 minutes break.
Your lordship.
So there are
Three writ petitions.
3 writ petitions.
Yes, so the two,
You are for 15.
261.
You are for item 15.
Yes, Your Lordship. Item 15 and
Oh,
two writ petitions, Your Lordship.
item 26, I'm sorry.
Yes, 26.
Item 26,
27.
27, you are for item 26, 27.
Yes, Your Lordship.
And Mr. Ezo, you are for item 28.
I'm the petitioner in that.
Item 28.
Yes, this all SB matter, yes.
Okay, Mr. Tongpok,
Yes.
kindly give us the gist of your case, 26, 27.
Yes.
Let us hear you first. Without going to the
Yes.
records, what is your case?
Item 261 is a challenge to the service rules. Some provisions of the service rules I have challenged. Then in the meantime, initially, since the division bench was not sitting at that point of time when it was initially filed, the learned single bench passed an interim order directing that no promotions may be granted with regard to the post of additional director, and that the interim prayer will be heard subsequently. Then during the pendency of the hearing of the interim prayer, in the entirety of the interim prayer in the writ, the promotion was granted to some of the assistant director, to a vacant post of assistant director. So we have challenged.
In W261,
Yes, 261.
what was the interim order?
The interim order?
Not to promote any person to the post of additional director.
Additional director only. But my prayer was that no promotions should be granted pending the writ. But the learned single bench decided that no promotion, but the interim prayer, the actual interim prayer will be heard subsequently.
Oh, that's why I'm saying, I'm asking.
Yes.
261.
Yes.
Interim prayer was only for the post of
Yes.
additional director.
Yes, additional director.
Okay.
And the condition was that the actual interim prayer will be heard subsequently before the division bench. That was the order.
Okay.
So pending the consideration of the interim prayer, promotion was granted to one of the employment officers to the post of assistant director, Your Lordship. So a deputy director, Your Lordship. So aggrieved by that, the petitioner has filed the 351.
So the main case is 261.
Yes, the main case is 261.
And Mr. Ashipre, what is your case in 170?
In 170. My lord, my learned friend filed 261, challenging the part of the rules, part of the schedules. Then during the pendency of that writ petition, they also filed another writ petition, which is subject matter of the learned single judge court,
Yes.
challenging the promotion order of another private respondent in 261, challenging the promotion of that. Then in the next writ petition, in item in W170 of 2022, I have filed this writ petition against petitioner number 1, questioning the legality of his entering into service as directly as principal, because that is not as per the provisions of the law. The post available in the service rules, he has to be routed through vice principal as technical department. But he was directly recruited as principal, which is 100% promotional post. So therefore, I have filed this co-warranto under 2226. Challenge questioning why he should not be ousted from the post. Now, yes, I have nothing to say.
When was he appointed? When
He-
was he appointed?
He was appointed most probably in 2001 or 2002.
And you are coming in before this court in the year 2022.
2021. 22, my lord.
22.
My lord.
After 20 years.
No problem. My lord, I'll satisfy. In case of co-warranto, there is no delay. Judgments are I'll show. That's why I have filed. Now, when he came to the service, he came directly as principal. He should have come as vice principal as per the rules. So when I questioned this, immediately he resigned and left. Petition number 1, he resigned and left now. During the pendency of his co-warranto.
He has resigned.
Resigned.
Your Lordship, not resigned, but taken voluntary retirement. He contested the elections, Your Lordship. He withdrew, Your Lordship may
Meaning
look at
therefore, my lord-
order
No,
that
no,
is-
just one by one, let us get your
That's
case.
okay,
Mr. Yezo,
Since he's, yes.
in your case,
Yes.
petition
to Divina.
you are the petitioner.
In
170, you are the petitioner.
Correct.
Who resigned? The petitioner in?
Petition number 1 in 261. When I questioned the legality of his appointment, he immediately took voluntary retirement. Because I'm questioning how can he come as a usurper? He cannot come as principal. So when he first came before the court questioning the service rules, part of the service rule, I came to know that he came through different means. So when I filed co-warranto, immediately he took voluntary retirement, he left. He disappeared from this court. That is the position now.
So
But still,
whether your petition survives.
yes, my lord, that is the question. See, now, if his entry point is illegal, how can the government give him pension? That question will come. Benefit,
But if the government is willing to give him?
my lord. So that question will be determined. If his entry point is found to be illegal, then consequential order will be illegal. He will not be entitled for pension also. That is my point, my lord. So that is before, this will be before learned single bench. This will not be the subject matter of the division bench. my lord.
Yes, 170.
Correct. And also my lord, 135 also, it will be 351 also will be SB matter. It cannot be analogous.
It should be subject to the outcome of the
No,
petition,
but it will
should
be subject to
yes.
the outcome of this WPC 261.
Yes.
But maybe I think this is a subject matter which is to be listed before single bench.
Your
Very
Lordship,
much.
this honorable, the
From
learned
day
single
one,
bench.
I'm pointing out
Yes.
this to this honorable
The
court.
learned single bench team did appropriate that it should be listed before, together with 261. So by an order, it was directed that it be listed together with this 261. Otherwise, it is a writ petition.
Whether actually WPC 351 will have a direct impact from the outcome of WPC 261?
I don't think so.
Whether it will have impact? Whether any outcome of 261 will have impact on 351?
Your Lordship, my only case is that there was specific order that the interim prayer should be considered before the next division bench. During the pendency of that, promotion was granted. Because of that, we were compelled to approach his honorable court.
Promotion,
Yes.
promotion to the post of deputy director?
Yes, deputy director.
And the interim order was not to promote anybody to the
Yes,
post of
yes.
additional director?
The single
So
learned single bench.
violation.
The learned single bench only in regard to one prayer, one part of the prayer for interim. And entire interim prayer should be considered only before the division, honorable division bench. That was the order. So because of that, the complication arose. But since these two are two different streams, Your Worship, the petitioner belongs to one wing and the respondent belongs to the other wing. Now, my case before this honorable court is that there is unequal distribution of posts and at the same time promotional avenue to the post of director. Only the rules specify that only from the employment wing, promotion to
Whether
director will be there.
your
So,
stream, whether
yes.
your stream is also eligible for promotion to the post of director?
No,
Whether your stream is eligible?
it should be. That is
No,
my
no,
case.
whether your stream is eligible or not?
Right now, as per the service rules, no. Because of
Your
that, we
stream
have
is
approached
eligible up to what post?
joint director, and even there also in the schedules, the main rules clearly lays down the two corresponding wings, equality of the equivalent post in the two wings up to joint director, and then director is the head. That is how Rule 3 clearly lays down. But in the schedule, what happens is that in the schedule, the distribution of posts are there. And in the distribution of posts, the number of posts of joint from deputy director onwards till the post of director, from deputy director, joint, they have deputy, there are sanctioned posts for them under deputy director, joint director, and director. And subsequently, the horse rules, they have also again.
What is your entry point?
The entry point is as vice principal.
In your stream, what is your entry point?
There are two entry points. One is the
I am
lower
asking
one.
about you.
There are two entry points. My entry point is from vice principal.
Okay.
Vice principal upwards. Now the schedule makes it clear that the post of director can be filled up only by the joint director of the employment wing. It is clearly laid down.
And you're from which wing?
I am from the training wing, Your Lordship. Training wing. Industrial training wing.
You're from the training wing.
Industrial training, yes.
And Mr. Ashipre is from the employment
wing, Your Lordship.
And actually, the promotional avenue is given only for employment wing.
Yes, with regard to director.
You are given promotion only up to joint director.
Even in the schedule,
You are given promotion only up to joint director.
It is shown like that.
Thereafter, you have no scope for promotion.
Yes.
And why should you be given the promotion to the higher post?
This is
why should you be given?
Because the rule 3 clearly specifies the equivalency of the two wings.
What does rule 3 say?
Your Lordship, I'll take Your Lordship.
Just explain to me first before I come to the record.
Rule 3 lays down the distribution of posts between the two wings, but then the number of posts are not specified there. But it is clearly shown that Nagaland under the two wings, joint director is there for employment wing, joint director is also there for the training wing. That is what the rule 3 clearly says. Now it is in the schedule that the problem arises.
In the rules, it says what?
In the rules, it says there are two wings.
There are two wings.
There are two wings.
It only
given.
says there are two wings.
Yes.
In rule 3, it only
Yes.
says there are two wings.
Yes.
In the schedule.
In the schedule now,
The
problem.
The post has been given. In the
Yes, the number of posts and then the promotional.
You're from which wing?
I am from the training wing, Your Lordship.
Training.
Craftsman training wing. Craftsman training wing.
Okay. So in rule 3, the posts are given.
Yes.
The posts are given.
Equivalent posts of the two wings.
Yes.
Up to joint director is given.
In rule 3.
Rule 3, Your Lordship.
In the schedule,
Yes.
their post goes up to director.
Yes, Your Lordship.
And your stream post goes up to joint director.
Joint director.
Why should you
and
be aggrieved?
Your Lordship, equality before the law. Equality before the
framing
law.
rules, I think that is the prerogative
we
of
also-
the government.
Yes, but then the government should frame the rules in such a way that both the wings get the opportunity to the top. That is my case. Equality before the law, Your Lordship. Equal should be treated equally, unequal treated unequally. Here in this case, these are two co-equal wings. But only one wing is allowed to go till the director. And the other wing,
As per the government, these two streams are different.
it is different, Your Lordship, but they are equivalent. Your Lordship,
How can you say equivalent?
Your Lordship, if Your Lordship,
When actually the service rule does not provide.
this is why I am challenging the service rules, Your Lordship.
And you have very limited ground.
My ground is that only. Yes, equality. Equality should be there. That is my ground. My ground is very limited to that extent only, Your Lordship. I am challenging the schedules, Your Lordship. Equal should be treated equally. Unequal.
You are not
unequally.
equal.
We are equal, Your
You are
Lordship.
from the different streams.
Your Lordship may see the Rule 3. Rule 3 makes it very clear, Your Lordship.
Rule 3 talks about employment wing and training wing.
Yes, and even the classification of the posts.
So you are not equal. You are from different streams.
We are from different streams, but we should be also given the equal opportunity.
You
to
said that
research.
you can be
That is my
given, you
case.
should be given, but you are
Yes.
not from the same stream. You are not from the same stream.
We are from different wings, Your Lordship.
Different
I
wings.
I agree to that. We are from different wings.
So the
But the thing
government,
is, if the government gives us, if there are two posts of director, all right.
so the government in his wisdom must have thought that the employment wing
No.
should be given the promotional post up to director.
Your Lordship, I'll take Your Lordship
How
to the
can we
history.
question the wisdom of the government?
Your Lordship, I'll take Your Lordship to the history of how these two groups, these two wings became amalgamated, and at the time of amalgamation, what was the position? From there, all the pictures will become clear. Prior to the amalgamation, Your Lordship, the employment wing had one post of deputy director, and then the higher post of joint director and director was normally held by the NCS officers. So the employment wing had only one deputy director at that point of time. When the amalgamation was effected, to bring into parity the two wings, a post of deputy director was also created for the training wing. Then what happened? The Service Rules 1998 was framed. In that, though it is shown that the two wings are co-equal, in Rule 3, when it comes to promotion to the post of director,
Okay, now you tell me whether
Yes.
promotion is a fundamental right. Whether promotion is a fundamental right.
it is not
It is
a fundamental right.
Yes.
But when
Yes.
when a co-equal,
And when what are the grounds you can challenge the rules? What are the grounds? One is legislative competence. One is a violation of fundamental rights.
Yes.
So when you say that actually promotion is not a fundamental right, how do
No.
we interfere?
Your Lordship, when promotion is given to equals on the other side,
You are not equals, I'm saying.
we are equals,
No,
Your Lordship.
you are from different streams. You are from different streams.
We are from different streams, but they have made us equivalent, Your Lordship.
You cannot assume that. You cannot assume that.
Your Lordship may kindly go to Rule 3. It is very clear in the Rule 3. One wing should not be made subordinate to the other wing, Your Lordship. This is my contention.
No, that is your contention, but if
Yes.
the government in its wisdom
In
feels
its-
that
the
one stream should be given more opportunities for promotion because of the nature of
yes,
work.
then there should be reasons, clear-cut reasons. There should be clear reasons as to why this one is superior to this one. There is no such reasons given in the service rules, Your Lordship.
No, not necessarily.
It should be based
Not
on
necessarily.
intelligible criteria, Your Lordship. Intelligible criteria should be there, Your Lordship.
No.
As per Article 14. Article
What
14.
you are saying is actually the conventional rights. Now, when you challenge the service rules, what are the grounds on which you can challenge service rules? You tell this court.
Fundamental rights?
Fundamental rights
Yes.
and legislative competence.
Your Lordship. Now, if the fundamental rights are violated,
Then if fundamental rights are gone.
No, Your Lordship. Fundamental rights.
You say promotion is not a fundamental right.
No, but
You say that.
Your Lordship, When equals are treated unequally, then it becomes a right,
You
fundamental
are not
right.
equals. You are not equals.
Your Lordship, when equals are treated unequally, then it becomes a fundamental right, Your Lordship.
When
Service rules
this
can
court
be
is of the
challenged.
view that you are not equals because you are from different streams.
Your Lordship
The law
may,
is very clear on this.
no, Your Lordship may hear me out. Take into
Before hearing
consideration
you
my-
out, I'll hear you out, but
Yes.
before hearing you out,
Yes.
I want to be very clear with the gist.
No, but when equals are treated unequally, then it becomes a fundamental right, Your Lordship. But per se, promotion is not a fundamental right. But when equals are treated unequally, then it becomes.
You are from the same department, but from a different stream.
I am agreeing to that, Your Lordship. We are two different wings, two different wings, but equivalent wings, Your Lordship.
How can you add that word equivalent when the government has not given that word equivalent?
Rule 3 clearly shows that it is equivalent, Your Lordship. Rule 3 clearly says that equivalent,
Mister,
Your Lordship.
when you interpret the rule, you should not add words.
I am not adding words.
Where does Rule 3 says that these two wings are equivalent? Where does Rule 3 says that?
Even if it does not
That's
specifically
why I'm
say
saying
that, but then
don't put words into the
yes,
rules.
but inference has to be drawn from the way it has been framed, Your Lordship.
If suppose
yes,
the words are ambiguous, not clear,
Yes.
then maybe we
Yes.
can make an interpretation
Your
so that the
Lordship,
rule works. But when
I
the
agree.
wordings are clear, we cannot put words. We have to go strictly, literally by the words.
yes,
in
Your
the
Lordship.
rules.
Let us go by strictly by what the rule says, Your Lordship. That is my only submission. Let us go strictly by what the rule displays.
Okay, we'll hear you.
Yes, yes,
Okay.
Your Lordship.
Okay, only 261.
Yes, Your Lordship.
Heard Mr. This is in item 27, okay? Heard Mr. Tongpok, the learned counsel for the petitioner, and MS V. Sokri. You are appearing here? MS V. Sokri, the learned counsel, learned additional advocate general for the state respondents, and Mr. Azo, learned counsel for the respondent
R5.
number 5.
My lord.
It is submitted by the learned counsel for the parties that the present case is a single bench matter, and therefore this matter may be listed before the appropriate bench. Stop. List the case before the learned single judge. Same with item 28, correct?
Yes,
Same with item 28. Okay, now. Okay, we'll hear you.
Your Lordship, before going into the other facts, I'll take Your Lordship to the service rules, Your Lordship. Page 63, Annexure E, Your Lordship. The Rule 3, Your Lordship. Page 66. If I may.
Where is Rule 3?
Rule 3, page 66, Your Lordship, page 66. Your Lordship has to turn the page around. It is in landscape. Constitution of Service, Your Lordship. Constitution of Service. The service shall consist of the following wings, headed by director, and under the wing of the following categories of posts shall be consisted. Director at the top, then on the left side is the employment wing. Nagaland Employment Service Class 1, number 1, A, Senior Grade 1, Joint Director. On the other,
Just wait.
yes,
The service shall consist of the following wings.
headed by
Headed by
director,
director and
and
under the wing
under
of the following
of the
categories
following
of
categories of
posts
posts shall be
consistent.
consistent.
Okay.
So the categories of post equivalent posts are clearly laid down. There are two entry grades here, Your Lordship. One is the Nagaland Employment Service Class 2, that is Employment Officer. And then on the other side, the Nagaland Training Service Class 2 Vice Principal. These are equivalent, these are the two entry points of the two wings. This is through the NPSC. And above C is a junior grade assistant director. The principal is an assistant director. So also under the junior grade of assistant director, district employment officer is the assistant director. P is senior grade 2, deputy director, principal senior grade. Deputy director is the deputy director and principal senior grade are equivalent. So also deputy director, regional employment officer. And A is the senior grade joint director. Under A, senior grade 1, joint director, and B, senior grade 2, deputy director, principal, senior grade. So the rule 3 nowhere says that it is these two wings are not co-equal. In fact, from a reading of the rule 3, it is very clear that these two wings are, though they are separate, they are co-equal.
How can you import that word co-equal? How can you import that word when the service rule is silent? Let us read. Let us actually explain the service rule as it is.
Yes, as it is, Your Lordship. But
it only says that
it only
actually
says
the
that
service
there
shall
should be a
consist
director.
of the following wings headed by the director under the wing of the following categories of posts.
Yes.
It only says that.
Yes.
It does not say that this will be co-equal. So please don't import words.
It does not say, but in the distribution of the post, equivalency is given, Your Lordship. Equivalency. Joint director of the employment wing is not superior.
See,
to the,
what we can read here is that this schedule selection grade is that actually the post under the employment wing is given, the post under the craftsman training wing is given.
yes,
That's all.
Your Lordship.
What more?
Your Lordship. Ultimately, it will be Your Lordships who will decide, Your Lordship.
No. I am hearing you.
My submission.
But I am telling you, I am actually telling you not to import words. Not to import words.
I am not importing.
You are.
But
when you say co-equal, you are importing.
Your Lordship, only from the way it has been laid down, one can say that these two posts are co-equal. Though the word co-equal is not there, though the co-equal word is not there, Your Lordship, my submission is that, my submission.
Okay, let us.
Yes.
That is the right word.
Yes, yes, yes.
Your submission.
Yes. Co-equal is not there, Your Lordship. I agree with Your Lordship, 100%. But from the inference can be drawn from this, from the manner in which the equivalent posts are laid down, from joint director downwards, one can come to the conclusion that these two wings are of equal nature. Because even the pay scale, everything is same for the two wings when it comes to equivalent posts. That is my submission, Your Lordship. But the word co-equal is not there. And it is also caged in very simple language, Your Lordship, the rules. It's very simple. This is why now we have to draw only the inferences from the distribution of posts, Your Lordship. So that's
What are the number of posts in the entry grade? Is it shown somewhere?
it is.
Number of posts in the entry grade.
I have in my affidavit in reply clearly laid down the number of posts, presently the present number of posts. In my affidavit in reply to the affidavit in opposition filed by the private respondent, Your Lordship.
One. In reply.
So the
Affidavit in reply to
the affidavit in opposition filed by the respondents number 5 to 16.
5 to 16.
Yes. This is reply to the paragraph 14
Yes,
of the
5 to
yes.
16. Where have you shown that?
From page 10, Your Lordship.
Page 10.
Yes.
So the
this is
entry, let's see, let us first see this entry point under the employment wing is technical assistant.
One is technical assistant. There are two entry points, Your Lordship. The senior entry point is for the employment wing, it is employment officer. For the training wing, it is vice principal. Then
No. Don't go fast.
Yes.
Let us, your entry point as per this selection grade.
Yes.
As per rule 3.
Yes, as per rule 3.
Your entry point is for the employment wing.
Yes.
Your entry point is technical assistant.
No, there are two entry points, Your Lordship. Two entry points. One is the lowest one is the technical assistant.
You forget about the training wing. You forget about that once. You forget about training wing.
Yes.
Forget for the time being, you forget training wing.
Yes.
Come to employment wing.
Employment wing is Nagaland Employment Service Class 2 Employment Officer.
Come to employment wing. The
Yes.
lowest post is technical assistant. This is the
Yes,
entry grade.
Technical assistant is a first entry
How
grade.
much post? Let us
Your
see.
Lordship.
How much post? In page?
In page 10.
Technical
Your
assistant,
Lordship.
10.
Yes, Your Lordship. Yes, 10, yes. And in the case of craftsman training, it is there, the trade instructor is a
90.
90, yes. And the next promotional for this is senior instructor. But the entry is trade instructor, 90 of them, Your Lordship.
You are given more posts. You are given 113 posts. The employment wing is given only 30 posts.
Your Lordship. And then,
There is disparity, but still the employment wing is not complete.
Your Lordship, in this case, what happens is, for the employment wing, there is only one, the next promotion for the technical assistant is employment officer directly. Whereas in our case, we have to go through two promotional avenues before reaching the post of vice principal, which is equivalent to employment officer. So
Now, because you
Yes.
have more employment avenues. That is why.
It is not that even the strength, if Your Lordship may go through the strength of both the wings, in fact, the strength is bigger in the training wing. But for them, the promotional avenue is with regard to the higher boss. They are not, without any rhyme or reason, they are not entitled to the higher post of director. That is the main contention.
You
Your
have a
Lordship.
bigger scope for appointment.
Your Lordship,
Training
bigger
wing.
post of appointment.
Bigger
Your
scope for
Lordship,
appointment. They have a bigger scope for promotion.
Your Lordship, equals should be treated equally, Your Lordship. That is my only contention. And if Your Lordship find that,
To that extent, I have
Yes,
made up my
yes.
mind. We are not going to give you that benefit. Equals should be treated equally. We are not going to give you that benefit.
Your Lordship, anyhow, Your Lordship may hear me out, and then
Yes.
ultimately it is Your Lordship's
So,
final
yes,
decision. It
we
will
are
be.
on rule 3.
So
We have read
that
rule
is it.
3. Then
Rule
next.
3, yes. Rule 3, it is the posts in the two wings are
Yes.
clearly laid down, Your Lordship.
Yes.
Then Rule 5 says.
Which rule 5 is page?
Rule 5 is next page, Your Lordship.
Page?
Page 67, Your Lordship. It points to the schedules.
Rule 5.
Yes.
Rule 5. This is method of appointment.
Yes, method of recruitment, qualification, etc. It says Schedule 2 is mentioned. And then strength of service, Rule 4, Schedule 1A and 1B.
Subject to the provisions
Yes.
of Schedule 2. What is Schedule 2?
I'll take Your Lordship to the schedules, right?
Yes.
Yes, I'll take Your Lordship to the schedules. But Rule 4 talks about the strength of service. They are pointing to the schedules, Your Lordship. That the schedules will make things clear.
Okay, Rule 5
Yes.
we have seen.
Rule 4 also, Your Lordship. And then Rule 5. But here, since it is general in nature, I am not aggrieved by this. Now, Your Lordship, I'll take Your Lordship to the schedule.
Yes, wait, yes.
Page 75 onwards. Yes.
Rule 4, you read the number of posts,
Yes.
permanent as well as temporary,
Yes, Your Lordship.
under each wing
Yes.
and category
Yes.
shall such as may be determined by the government from time
To time. Yes, Your Lordship.
Have you challenged this? Have you challenged this rule, Rule 4?
No, Your Lordship. Because it is clearly laid down that Schedule 2, on the commencement of these rules, the strength of the service, permanent as well as temporary, together with the scale of pay attached to the post, has been shown against each in Schedule 1A and B, provided that the number of posts, both permanent as well as temporary, under each wing by the government from time to time. So it only boils to the schedule. So far as this A is concerned.
This rule
It is
4
to be
gives
determined by, yes, it is to be,
discretion to the government.
yes, it is to be determined by the government, Your Lordship. But the government, my only case is that government should determine it in accordance with the fundamental rights. That is my only case. My only case is that. This is why, since here, it does not.
Mr. Tongpok, you have very, very, very limited
Yes.
scope to challenge the service rules. You are very limited.
I am challenging only the schedules, Your Lordship. And if Your Lordship may consider it, that is my only
Okay,
prayer.
we have read
Your
rule
Lordship.
4 and 5.
Yes, now I'll take Your Lordship to the schedule.
Schedule 1.
Schedule 1A talks about the employment wing, Your Lordship.
Let us see where is that schedule.
Page 75, Your Lordship. Schedule 1A, selection grade director, the number of posts that has been shown, Your Lordship. One post. B, senior grade 1 joint director, 1 post is shown. 1 is no permanent post, only temporary post, and then 1 is shown. Senior grade 2, that is deputy director, is 1 post is shown. 2 temporary posts, and altogether it is 3. Junior grade, that is assistant director, regional employment officer, one regional employment officer is equivalent to deputy director, Your Lordship. So altogether there are 4 posts of deputy director under the employment wing. Next is junior grade assistant director. There are 2 temporary posts, so altogether they have 2 posts. Then Nagaland subordinates, I am only concerned with the higher posts up to assistant director and district employment officer. So there are 8 posts. Schedule 1P, Your Lordship.
Just wait 1 minute, let's see. What is this G within a bracket?
Gazetted.
Gazetted, is it?
Gazetted, yes,
Okay.
it should be gazetted.
Plus 1 G.
Class 1 gazetted. 7 is the employment officer, which is class 2 gazetted. The entry point is the employment officer, Your Lordship.
Entry point is technical.
Your Lordship, there are 2 entry points, Your Lordship. There are 2 feeder grades. 2 feeder grades. The officer grade starts from employment officer. This recruitment is done through the NPSC.
What is the ratio for promotion direct? Where does it say?
So from here, from employment officer, the next promotion is the district employment officer.
That I understand.
Yes, so it goes on.
Where is the ratio?
No ratios later. No ratios.
You were saying actually there are 2 feeder grades.
Yes.
2 feeder grades.
Technical assistant from here, the next promotion is employment officer only.
That's why
Yes,
you were
yes.
also saying that the employment officer is also a feeder grade.
Yes.
Where is that?
It is a fact, Your Lordship. It is a fact. Even the learned government advocate will verify that.
We go by the rules when there is
Yes,
rules.
but yes.
When there is no rules, discretion is given to the government to say something.
Your Lordship, but the factual position is that only. So far as my knowledge and information is concerned, there are 2 entry points in both the wings. Yes, that is my information.
I found only one.
But direct recruitment is done under these 2 categories. One is technical assistant,
That is why
Yes, and the other one, yes,
actually, we
yes.
are asking you to show us the ratio of appointment to employment officer and the ratio of post to appointment to technical assistant. Because if there are two feather grades,
Yes.
suppose from
Yes.
technical assistant to come to employment
Yes.
officer,
Yes, Your Lordship.
by promotion, there must be certain ratio.
Yes, Your Lordship. That is not
And,
there.
and
that is
for
not
direct
there.
appointment to employment officer, there must be some ratio direct appointee.
Your Lordship, true.
Where is that?
There, I have no information regarding that, Your Lordship. But my information is that, yes.
78.
Oh, Your Lordship, yes.
So you have not done your homework. Technical
50%.
assistant. Technical assistant. Direct recruit. 100. Employment officer 50%. By promotion 50%. This is
Yes.
what I'm asking.
Yes, yes. So Schedule 1A is with regard to the employment wing. Schedule 1B is with regard to the Nagaland craftsman wing. That
Okay, let's see the craftsman has
So here,
post only up to
Deputy Director.
Deputy Director.
Yes, this is where I am aggrieved with. It is shown here under Schedule 1B only up to one post of Deputy Director. Whereas in the case of the employment wing, there are 4 posts of Deputy Directors, Your Lordship. And Principal Senior Grade, 1. Even this Principal Senior Grade post, where it has disappeared, we do not know, Your Lordship. But it is shown as Principal Senior Grade. No promotion has been made to the post of Principal Senior Grade till date. Then Junior Grade, 2.
Okay.
Now, Your Lordship, Schedule 2A, Employment Wing, Your Lordship. It is
2A.
2A,
2A in which page?
Director. And next page, 77, Your Lordship. I'm taking Your Lordship to the page 77. Yes. Director. Here I am aggrieved by the eligibility and other conditions for promotion. The post shall be filled by selection from amongst confirmed officers mentioned under Rule 3A1. Rule 3A1, A, that means it is only for the employment wing. This
From amongst officers mentioned under Rule
3A1,
3A1.
A, small, lowercase a.
Provided that the
That the
officer has
completed qualifying and yes.
continuous service of 3 years in that grade. Joint Director 3A1B. Provided that the officer, Deputy Director 100%, Rule 3A1C.
I am only aggrieved by the director, Your Lordship, promotion to the
You
director.
don't have Joint Director also?
Here in the rule schedule 2B training wing, in the next page, Your Lordship, 79, joint director is given. This is a joint director, Your Lordship. This is with regard to the training wing. The post shall be filled by selection from amongst confirmed officers as mentioned under Rule 3B, 1B, provided that the officer has completed qualifying and continuous service of 3 years in that grade on the first day of the year on merit cum seniority basis.
So basically your grievance is only against the schedule.
Yes, I am against the schedule. The schedule is neither making rhyme nor reason, Your Lordship.
So in the schedule, you are given promotion of the Joint Director.
Yes, joint director. But the fact is that from joint director, there is no right to reach the post of director by virtue of the schedule 2B, 2A. Schedule 2A, 1. Only those from the employment wing can go up. And then there is no criteria as to why there is no reason, there is no criteria as to why only these joint directors from the employment wing can reach the post of director. That is my main issue, Your Lordship.
Okay.
Yeah. Your Lordship, I'll take Your Lordship to the genesis of the how the employment wing and the training wing came to be amalgamated, Your Lordship. I'll take Your Lordship to my statements in the writ petition because they are more coherent than if I try to explain it
Yes.
verbally, Your
Para.
Lordship. Yes, paragraph from para 3 onwards, Your Lordship. Para 3. That the Directorate of Employment, Skill Development and Entrepreneurship, Nagaland, is composed of two wings, namely Employment Wing and Craftsman Training Wing. Initially, the Craftsman Training Wing, then called the Industrial Training Institute, hereinafter referred to as the IDI, was under the Education Department. Going further back in time, up to 1972, the IDI was called Polytechnic School. As per the record available in 1971, the then Director of School Education by letter number so-and-so dated 27/8/1971 wrote to the government requesting issuance of orders for converting the Polytechnic School to Industrial Training Institute. And the proposal to convert the Polytechnic School to IDI having been submitted to the Government of India. The Government of India by letter number so-and-so dated 26/9/1971 gave its consent to the proposal. Subsequently, the IDI was placed under the Labor and Employment Department, that is under the government. And thereafter, by order number so-and-so 81 dated 25/1985, the IDI was transferred from the Labor and Employment Department and placed under the administrative control of the Directorate of Employment Exchange, and the Directorate of Employment Exchange was redesignated as the Directorate of Employment and Craftsman Training. At the time of the merger with the Employment Exchange, there were only two IDIs, one at Kohima and the other at Dimapur. Subsequently, IDIs were established in all the other districts of the state, with Mon, Zeniputo, Wokam, Mokokchung, Tuinsang, Pek, and Kifiri, respectively. Then next paragraph, paragraph 4, that it is pertinent to state herein that at the time, the IDI was placed under the administrative control of the Directorate of Employment Exchange. The Directorate was governed by the Nagaland Employment Service Rules 1984. And up till then, the highest ranked post available to the Nagaland Employment Service was one sanctioned post of Deputy Director, which I'll take Your Lordship to the annex here. One sanctioned post of Deputy Director Class 1, gazetted, and although provisions were made in the said rules for higher posts of joint director and director, there being no sanctioned post for the same, the post of director was held ex officio by officers of the Nagaland Civil Services. Schedule 1, White Rule 4 of the said rules, which highlights the breakup of the post and the number of sanctioned posts for each grade, shows a sanctioned post only up to deputy director. That is at Annexure P, Your Lordship. Then paragraph 5, Your Lordship, that also at the time the IDI was brought under the administrative control of the Directorate of Employment Exchange, there were only two IDIs, IDI Kohima and IDI Dimapur, and these two IDIs were under the administrative control of a principal H. Therefore, upon the merger, the government by letter so-and-so dated 24/10/1986 conveyed approval to the creation of one post of Deputy Director, Class 1 gazetted for Craftsman Training Wing. Thus, by the creation of the said post of Deputy Director, the Craftsman Training Wing was brought to parity with the Employment Wing. So the two wings were brought to parity by the issuance of the order in respect of the Craftsman Training Wing also.
What was the reason?
Your Lordship.
What was the reason for giving them parity?
Your Lordship, the letter, I'll take Your Lordship to the letter because I cannot go beyond what is in the record, Your Lordship. I cannot. So I'll take Your Lordship, but that was the position. That was the position. If Your Lordship may allow me to take you to Your Lordships to the annexures?
Yes, yes. Please.
Annexure B is the Nagaland Employment Service Rules. That is page 38.
Annexure
B. Page
B.
38. Yes.
Page?
Page 38, Your Lordship. I have.
Page 38.
Yes, page 38. This is the cover photocopy of the cover, Your Lordship, and the relevant.
Page 38 is Nagaland Employment Service Rules.
1984.
This was before the merger.
Before the merger. I am taking Your Lordship to the Schedule 1, which is at page 39, Your Lordship.
Just which?
Page 39. Here, Your Lordship.
Just wait.
Yes. Page 40 is a typed copy, Your Lordship. Page 40 is a typed copy.
Yes, which page?
Page 40 is a typed copy of page 39, which is
Okay.
clearer, Your Lordship.
Page 40.
Yes. So if Your Lordships may go to A, selection grade, director, there is no post. No sanction posts. B, senior grade, joint director, there is no sanction post, Your Lordship. Only senior grade 2, deputy director. There is one sanction post.
This you are
Yes,
showing
this
that
was my-
before the merger there was no post of director, joint director. Only to
Yes,
show
yes,
that.
yes. So now, after the merger,
Yes.
by the order at Annexure C, page 41, the type copy is at page 42.
Just wait. Page 41.
Page 41, Annexure C, and then type copy as page 42, Your Lordship.
See that too.
I seek your lordship intelligence about item number 30. Let it be listed in the next available TV. It's not likely
Item
to.
30.
Lordship,
You-
make it after 3 weeks, Lordship.
You are the counsel for the? You are the counsel for the?
Folder respondent.
Who is the,
I'm the appellant, Your Lordship.
okay, on the prayer of the learned counsel for the parties, listed after 2 weeks.
Yes.
May I please, Your
Lordship,
Lordship?
I pray that item 31, this should be for the appropriate bench. It's a single bench matter. 31.
Item, who is for the other side?
Yes, Your Lordship.
What is item 31? What is it about?
Your Lordship, here, this is for regularization of service. However, Your Lordship, here, the nature and the facts of the case is different. So Your Lordship may kindly segregate the matter, and then since this is a single bench matter, let the matter be listed before the single bench after 1 week, Your Lordship.
Okay, we will see, because we had actually passed the order to be listed along with the read appeal. So let us see.
Your Lordship, if allowed, kindly segregate the
That's why
matter.
we will see when the matter comes. Let us see. We'll segregate, but let us see. Let us see.
Then again, Lordship, item number 32 to 36 or so, Your Lordship, with the consent of the parties, I pray this matter may come up after 3 weeks, Your Lordship.
That includes 30 also.
No, because, yes, that includes 30.
Oh, 32?
32
Okay,
to
okay,
36.
okay.
Yes, yes.
Item 32 to 35.
35, yes, Lordship.
Item 32 to 35.
Yes, yes.
Correct.
Yes.
Who is for the other side?
And for the respondent, Your
On the
Lordship.
prayer of the learned counsel for the parties, listed after 2 weeks.
Lordship, make it after 3 weeks.
Why?
Lordship, I have other engagement.
Listed
next-
after 3 weeks. Okay.
Thank you. Much obliged.
Yes.
Yes, Your Lordship. I was taking Your Lordship through the annexures. So in 1986, the amalgamation was
Page 41.
in May 1986, Your Lordship. The order is at page 36, annexure A3. The
Page?
Page 36. This is the order by which the then IDI, Industrial Training Institute, was brought under the page 37 is a type copy, Your Lordship. Page 37. This is May 86.
What is this?
This is the order by which the IDI, that was then it was called the Industrial Training Institute Kohima and Dimapur. It was under the labor and employment under the government. I have made statement in my petition also the history. Your Lordship, I have taken Your Lordship to the paragraph 3. But this is the record whereby ultimately it was brought under the
ITI is now the training wing.
It is now the training wing, but the name has, the nomenclature has taken a slight change, Your Lordship. Now it is called the Craftsman Training Service, Craftsman Training Services. At that point of time, it was ITI. The nomenclature
Yes,
changed
please
slightly
read.
there. So the governor of Nagaland is pleased to transfer the establishment of the Industrial Training Institute Kohima and Dimapur from the Labor and Employment Department and place it under the administrative control of the Directorate of Employment Exchange Nagaland, Kohima, which with immediate effect. The Directorate of Employment Exchange is herewith designated as the Directorate of Employment and Craftsman Training. These issues with the clearance of PNAR department-wide UO number 541 dated 16/5/86. So by this, the two wings were brought together, Your Lordship. And this is in 1986 itself, Your Lordship, after this merger, Your Lordship, page 41. Page 41, the type copy is at page 42, but Annexure C, Your Lordship. Annexure C.
Annexure?
Annexure C. Page 41, Annexure C, the type copy is at page 42. This is the creation of post of Deputy Director, Class 1 for the training wing, Your Lordship. So at this point of time, the employment wing also had only one post of Deputy Director, as per the service rules, Your Lordship. So by this post creation, one post of Deputy Director for the craftsman training was created, Your Lordship.
Read it.
One post of Deputy Director, Class
Read it.
1. Yes.
Read it.
I am directed to refer on the above cited subject and to convey the approval of the Governor of Nagaland to the creation of one post of Deputy Director gazetted for craftsman training. Nagaland in the scale of pay of rupees so and so per month plus an inner line compensatory allowance, 25% of basic pay subject to a maximum of so and so, and all other allowances as are admissible from time to time in Nagaland with immediate effect.
So by this letter,
Yes.
the post of deputy director was created.
Created, yes, for the craftsman training.
Craftsman.
Yes, after the merger, in the same year, Your Lordship. That is my. Now, Your Lordship, I'll take Your Lordship back to my statements because it is. I have tried to simplify it in my statements, Your Lordship.
Yes.
Paragraph 6, Your Lordship. Page 13. Page 13. Page 13. That, however, if I may read, Your Lordship. If I may read, Your Lordship.
Yes.
That, however, despite the creation of the post of Deputy Director for the Craftsman Training Wing, promotion to the post was not granted to any officer of the Craftsman Training Wing. Meanwhile, within a year of the merger of the two wings, Sri Sizoli Sorho from the Employment Wing was promoted to Director with effect from 12 to 1987, though there was no sanctioned post of Director as per the relevant 1984 rules. Similarly, in the absence of sanctioned post of Joint Director, Sri Bangar from the Employment Wing was promoted to Joint Director with effect from 23/9/1996. With the said promotions, steady promotions in all grades were maintained in the Employment Wing, so much so that all the posts from Deputy Director to Director were continuously held by officers of the Employment Wing, whereas in respect of the Craftsman Training Wing, the wing continued to remain stagnant at the grade of Principal Assistant Director, until finally, for the first time, promotion to Senior Principal Deputy Director was granted to Engineer M.P. Wabang from the Craftsman Training Wing with effect from 24/1/2004, and his promotion was regularized as Deputy Director in 2006. Subsequently, Engineer M.P. Wabang went on deputation to the Transport Department in 2006 and was absorbed in that department. However, strangely enough, after Engineer M.P. Wabang's departure, Sri Yikoto Awomi from the Employment Wing was promoted against a vacancy with effect from 3/8/2006. Thus, again, from the 2006 onward through 2018, not a single promotion to Deputy Director was granted to the Craftsman Training Wing, and all posts from Deputy Director and upwards were again continuously filled up by officers of the Employment Wing. The fact that all posts from Deputy Director to Director were continuously filled up by officers belonging to the Employment Wing from 1986, that is the year of merger of the two wings, up to 2018, except for the 2 years, that is 2004 to 2006, during which Engineer M.T. Wapang from the Craftsman Training Wing held the post of Deputy Director may be ascertained from the following notifications, orders, and memorandums. Number one, by notification number so-and-so dated 25/8/2000, Shri S. Kevin, Deputy Director, Employment Wing was allowed officiating promotion to the post of Joint Director. Number two, by notification number so-and-so dated 10/10/2003, officiating promotion of Shri N. Pangar, Joint Director, Employment Wing, and Shri S. Kevin, Joint Director, Employment Wing were regularized. Number three, by notification number so-and-so dated 18/11/2003, Shri N. Pangar Jamir, Senior Most Joint Director, was given charge of Director upon the retirement of Shri K.V. Sizoli Soho. Number four, by notification dated 18/10/2004, Shri N. Pangar Jamir, Employment Wing, was promoted to Director. By order number so-and-so dated 4/11/2004, the following officers from the Employment Wing were granted officiating promotion. Number one, Shri Muting Yuva Sangdam, promoted to Director. Two, Shri Alam Longkomer, promoted to Deputy Director. Three, Shri Tipang Ziliang, promoted to Assistant Director. Shri Ipon Sao Lota, promoted to Employment Officer. Number six, by order dated 3/8/2006, officiating promotion was granted to the following officers from the Employment Wing. Number one, Shri Yukoto Awomi, promoted to Deputy Director against the deputation of Shri M.D. Wabang, Deputy Director, Training to Transport Department. Two, Shri Wizeho Chakesang, promoted to Assistant Director. By notification number 7, dated 14/11/2007, the officiating promotion of the following officers from the Employment Wing were regularized in the post of Deputy Director, Regional Employment Officer. Number one, Shri Muting Yuba Sangdam, with effect from 25/1999, Shri Y. Waptan Shan Lota, 25/1999, Shri Chingyak Konyak, with effect from 1/8/2000. Number 8, by notification dated 31/8/2010, officiating promotion was granted to the following officers from the Employment Wing. 1, Shri Kukie Sima, promoted to Deputy Director. Number 2, Shri Wiziho Chakisang, accommodated on regular officiating promotion as Assistant Director. Number 3, Srimati Rukupino, promoted to Employment Officer. 9, by notification number so-and-so dated 31/3/2011, officiating promotion was granted to the following officers from the Employment Wing. 1, Shri Muting Yuba Sangdam, promoted from Additional Director to Director. 2, Shri Y. Wandan Shan Lota, promoted from Joint Director to Additional Director. 3, Shri Chingnak Konyak, promoted from Regional Employment Officer Kohima to Joint Director. Number 4, Shri L. Lipimo Lota, promoted from District Employment Officer to Regional Employment Officer. Srimati Songjam Gala, promoted from Employment Officer to District Employment
Just pause
Officer.
for a
All this-
moment, Mr. Tongpok.
Your Lordship, yes.
There is one post, additional director.
This was created only recently. It is not in the service rules. Somehow, from one of the employment officers who was in the joint post of Joint Director, he was given that promotion and a post was created by the government. And all these years, we have not been getting our...
This promotion to the additional director, this was by notification 31/3/2011.
Yes.
Correct.
Yes, yes. Actually, in the service rules, this post is not there. It was subsequently, I'll come to that, Your Lordship. It was subsequently created. So,
yes, yes.
Number 10, by notification number so-and-so dated 3/10/2012, the following officers from the Employment Wing were granted officiating promotion. Shri R. Oren Muli, District Employment Officer, promoted to Deputy Director. Srimati, number 2, Atauna Ziliang, Employment Officer, promoted to District Employment Officer. 3, Shri D. C.O.B. Sangdam, Technical Assistant, promoted to Employment Officer. Number 11, by memorandum number so-and-so dated 14/4/2014, the BNAR department intimated the upgradation of one post of Deputy Director out of existing 3 posts to that of Joint Director. These are all promotions
In the employment wing.
Only the employment wing were being promoted continuously. Only in 2004, one from the training wing was promoted to Deputy Director, but then he went on deputation, yes. And then the vacancy left by him was filled up by employment. So during this period, the 1998 rules was brought out, Your Lordship. We were being denied any kind of promotion all these years. So everything was under their control, under the control of the employment wing when the rules came out, Your Lordship. The annexures are T1 through T14. All these notifications whereby promotions were made, annexures T1 from T1 to through T14, which is starting from page 43 to 61, Your Lordship. So all these years, because of this, obviously the service rules also came to be framed in the manner which is presently before this honorable court.
Yes.
Yes, Your Lordship. I'll take so from T1 to T14, all these notifications and memorandums are to be found. Paragraph 7 is with regard to the service rules. Paragraph 7. That if I may read, Your Lordship, that by notification number so-and-so dated 22/10/1998, the Nagaland Employment and Craftsmen Training Service and Nagaland Subordinate Employment and Craftsmen Training Services Rules 1998 was brought into effect as an amendment to the 1986 rules. The anomaly and therefore unconstitutionality in the said rules is that while Rule 3, which makes provisions for constitution of the service, clearly provides that a service shall consist of two co-equal wings, A, Employment Wing, and B, Craftsman Training Wing, headed by Director, and Schedule 2B, Serial Number 1, provides for a post of Joint Director for the Craftsman Training Wing, while the impugned Schedule 1A shows one post of Joint Director and 4 posts of Deputy Director for the Employment Wing. The impugned Schedule 1B shows that the highest ranked officer for the Craftsman Training Wing is one post of Deputy Director, and further, the impugned Schedule 2A, Serial Number 1, shows that the post of Director shall be filled by selection from amongst confirmed officers mentioned under Rule 3A1A. Rule 3A1A is a senior grade 1 joint director under employment wings, while Rule 3B1A is a senior grade 1 joint director under craftsman training wing. The two posts are exactly equal. It is obvious from a reading of the Rule 3 that the two wings are co-equal, with neither of them being inferior to the other. The grades of posts in the employment wing are equivalent to the corresponding grades of posts in the craftsman training wing, and vice versa. Yet, without any rhyme or reason, the impugned Schedule 2B makes it possible only for the joint director of the employment wing to be promoted to director. This is a classic example of equals being treated unequally and therefore utterly unconstitutional. Now, paragraph 8, Your Lordship.
What is the qualitative difference in the work? What is the qualitative difference in the work?
One is with, one is with regard to employment exchanges.
So what is the nature of work in the employment wing? And what is the nature of work in the craftsman wing?
Craftsman wing is with regard to trainings, Your Lordship, looking after the trainings of the institutions.
And employment?
And employment is with regard to the employment aspect, employment exchanges.
Administration.
Employment exchanges, Your Lordship. Administration in that sense.
Give me in a simple term.
Administration.
They look after the administration.
Yes. Both are looking after administration of each wings, Your Lordship. In their own way. Those under the training wing, they look after the administration of the training wing. So also the employment wing also looks after the administration of the employment wing. That is the position, Your Lordship.
So what is the qualitative difference in the nature of the work? I want to get it in a very
Your
simple
Lordship,
language.
I cannot be able to give Your Lordship, to be honest, because that is
That is where your case lies. You are actually seeking for some relief,
yes,
stating that the state government has discriminately treated you.
yes, Your Lordship.
So in order to actually substantiate that
Yes.
issue, you have to answer
Yes, Your Lordship.
what is the qualitative difference or the nature of work between these two, so that we also understand your case better.
Your Lordship, and I have to go only by the service rules. So
No.
yes, Your Lordship.
Because actually you have a close liaison with your clients and all this. So all these things you should have been able to, I think, brief the court.
They have their
Because
own.
actually,
Yes.
who knows? I
Yes.
am not
Yes,
very
yes,
sure,
Your
but maybe the government taking into consideration the qualitative difference in the nature of work, they must have created this post also. So that is why we should know what is the qualitative nature of work for the employment wing and for the craftsman wing. We should know.
Your Lordship, true.
We should.
But then the government also should, since these are two disparate wings being joined together, the government should also make it very clear in the.
For the time being, you
Yes.
forget about government. For the time being,
Your Lordship.
it's your case.
Your Lordship.
You have to build up your case. You have to satisfy us
Your
with
Lordship.
your case. So that, see, this is the issue. We are discriminated in spite of them, in spite of both the wings performing similar nature of work. We have been discriminated. So in order to show that, you should also be able to show us the qualitative nature of work performed by the training wing as well as the employment wing. The duty is cast on you.
Since these are two different wings, they
Two
are
different
yes,
wings,
two
that we
different wings.
understand.
So
Okay,
you cannot we
say that.
cannot compare. No, the central manual is also not in a sense enforceable in the court of law, but there are instructions under the central manual, central government manual. It is there in this. It is there annexed to the affidavits, Your Lordship. So the manuals will speak for itself in that respect.
Yes, madam, can you enlighten this court about the nature of work performed by this employment and this training?
Yes, Lordship.
Just that part. We will let Mr. Tongpo continue.
Lordship, for the employment is non-technical and they are executive in function. Then the training wing is technical and institutional in nature. They are institutional in nature. Then Lordship, for the employment, they used to collect the data of all the qualified unemployed youth, and they collected the data who are seeking for job, and then they put up to the make the compilations, and then in what trade needs to be opened. So they put up this national classification of occupation. They identify those trade and they put up to the central government for main power planning, Your Lordship.
Okay.
Yes. Whereas the training wings, they are they teach the school dropout students.
In various trades.
Yes, in various trades, Lordship. So it's quite very different. The
Have
nature
you stated this submission in your affidavit? Have you stated all the submission in your affidavit about the difference in the nature of work and all this?
Lordship, that is not in my affidavit.
No.
Yes. That
It
is
is
not in
not.
my affidavit, but that is the factual position, Your Lordship. Yes.
Because when we write judgment,
Yes.
we have to base our judgment on your affidavit.
But Your Lordship,
So we cannot leave a vacuum in one area.
my apology, Lordship, I inherited this brief from.
I know.
Yes, so Lordship, but that's the position, Your Lordship. Because these two wings are quite totally different, the nature, the work. One is institutional, the other one is, Lordship, executive in function, which is non-technical. Even the entry, the qualification, everything is different. And they are under the concurrent list. So the.
We will hear you, but we
Yes.
will give you time. You file additional affidavit also on this.
Lordship,
That will be important for us. It will be important.
otherwise, Your Lordship, what I'm stating today, that can be taken on record also.
Pardon?
What I'm submitting
no,
regarding
no, no.
about the functions of the department, the two wings, that can also be recorded as a
No,
part
no,
of
no,
my.
no. Oral submissions,
Yes.
I think we are quite reluctant to make that record.
Otherwise, at the
We
time
will
of
give you a chance.
Lordship,
We will give you a chance.
at the time of hearing, we can show through the national manuals and the vocational manuals, the training manuals, everything, how everything we can show.
This court wants you to file an additional affidavit stating the qualitative nature of work and the difference in the nature of work between these 2 weeks.
Okay.
That will be important for us. That will be important for us.
Okay, Lordship, if that is please.
Okay, yes. So we will, without that, let us continue, okay? Let us see. Okay, but that will be important, so let
Yes.
us.
Your Lordship, the nature of work in the two wings are completely different. That is obviously
different,
true. That
yes.
is completely different. The manuals are also here in the affidavits, Your Lordship. So the National Employment Service Manual is also there, and then the Industrial Training Institutes Manual is also there, Your Lordship.
Let the government file an additional affidavit explaining the nature of work performed by the training as well as the employment. Yes, so continue, let us see.
Your Lordship. Paragraph 8, Your Lordship. That are stated herein above in paragraph 6, except for the 2 years, that is from 2004 to 2006, during which Engineer M.T. Wabang held the post of Deputy Director from 1986. That is the year of the merger of the two wings. Onward, all posts from Deputy Director up to Director were filled up by officers from the employment wing, contrary to the service rules of 1998. Finally, again, in 2018, Engineer Gauhati, that is the petitioner number 1, who has now he is no longer a party here, but since it has been stated, from the Craftsman Training Wing was promoted to Deputy Director with effect from 25/6/2018, which fact may be ascertained from the order dated 24/9/2019, which also clearly reflects the undue advantage enjoyed by the Employment Wing. Thereafter, by order dated 18/10/2019, the petitioner number 1 was granted officiating promotion to Joint Director, and TPC having been conducted by the NPSC, and the NPSC by letter dated 15/9/2021 recommended regularization of his promotion to Joint Director with effect from 18/10/2019. By order number so-and-so dated 16/9/2021, his officiating promotion has been regularized with effect from 18/10/2021 by the NPSC recommendation dated 15/9/2021. And the order dated 16/9/2021, Sri Savio Visa from the Employment Wing also was regularized as Joint Director with effect from 27/7/2021. Thus, the present position is that the petitioner number 1 is the senior-most Joint Director. It is pertinent to state herein that subsequent to the promotion of the petitioner number 1, the petitioner number 2 was promoted to Deputy Director with effect from 4/6/2020. The fact that the petitioner number 1 is the senior most joint director can be ascertained from the latest updated seniority list of gazetted officers from both the wings under Directorate of Employment, Skills Development and Entrepreneurship, Nagaland, Kohima.
Okay, Mr. Tongpang.
Yes.
Just one clarification. Is there a separate gradation list maintained for these two wings?
There separate lists are maintained, yes.
Separate gradation list?
Seniority list only.
That's why
Yes,
gradation
yes,
list.
yes, separate. Up to joint director, it is separate. It is separate, Your Lordship. But only from recent times, these the craftsman training officers, as is stated herein, the petitioner number 1 was promoted to deputy director, and from there.
And when
joint
was
director.
this gradation list maintained? When was this gradation list maintained? Seniority list, when
Seniority
was it
list,
maintained?
I have given the seniority list in the page 92, Your Lordship. No.
Okay, we'll come to that, but
Yes,
we just wanted to know whether
Yes.
they have a separate gradation list.
There were no such lists till this 2021, Your Lordship, because obviously the others were, the craftsman training wing were not.
And
getting
have you
promoted.
challenged that gradation list?
No, Your Lordship, I am challenging only the.
Please take note of that.
Your Lordship, I am challenging only the service rules. If the service rules is affected, then if the service rules, I am not agreed by the fact that there are two different wings. I am satisfied, but only with regard to the promotional aspect to the post of director. Why? That is my only question, Your Lordship. Why we should be denied equal opportunity when it comes to reaching the post of joint director? Why equality should not be maintained for the two wings, though they are separate? That is my only case. So obviously, comparative, after looking at the comparative seniority list of the two, promotion can be given.
We will see
Yes.
what the government will submit, but normally when rules are framed, there is very, very little scope for this court to intervene.
Your Lordship, I'll try to
Hear the government.
yes, I'll try to satisfy your Lordships. If your Lordships are not satisfied, what more can I say? What more can I say?
Till now, we are
But
still
I'll
confused.
try to. I'll take your Lordship to the fact, and then I'll place only one or two judgments as to how this Article 14, the interpretation of the equality thing, and then if your Lordships are not satisfied, what more can I say? It is not up to me. I'll try my best. I'll try my best to take your Lordships through the facts, because only the facts and the records are there to show, to support or go against my case. If it goes against my case,
I don't know whether, I think you are all very familiar with that, I forgot the title of the case. 1973 Supreme Court, EIR, full constitutional bench, where actually a person who was serving as assistant engineer and who was not given any promotion thereafter had challenged the actions of the government on the ground that no promotional scope has been given to him. But the court said that in service matters, especially when the rules are framed, unless the rules, the petitioner challenging the rules can satisfy that the legislature had no competency to frame the rules,
yes, Your Lordship.
or there is a violation of fundamental rules,
Yes.
the court normally will not interfere. But 1973, that
19
EIR,
1974 SCC is a similar case. In this case, the fact was that through promotion, someone who was not a graduate, engineering graduate, he was promoted to assistant engineer. And the other one who was qualified, he was promoted, he was also assistant engineer. They were in the same rank. But when it comes to promotion to the higher rank, because of the educational background,
yes,
he was being denied.
that was
But
one
that
was
is
not,
a distinction. That
one
is,
was not
yes.
qualified.
Yes, But then in this,
Here is a case which I
here
am
is a case
referring.
in which both are equally qualified. The ranking in the two corresponding wings are similar. So here there is no clear-cut distinction between the
No,
two.
what
That is my only.
the question what we are raising is that you will have to satisfy this court that there was violation of fundamental rights, or the
Yes, yes.
legislature was not competent.
If from the facts and from the record, your lordships find that there is no violation of the fundamental rights, what more can I say? I am giving whatever is here. My statements are very clear in my petition, and based on the records that are available to me, your lordship. So
Your
I'll-
petition is full of denying you promotion.
Yes, but because we did not approach the court earlier, your lordship.
No, that's
Yes.
okay. That's
Yes,
okay.
yes.
Anyhow,
So that paragraph 8, your lordship, is one of the history with regard to how we came into being promoted to deputy director and director, a joint director, your lordship. Then with regard to the additional post of-
so as of date, you are the senior most joint director.
I was. Now I have retired. The petitioner number 1 has taken voluntary retirement. He contested present
This Mr.
the
Wati.
election. Yes, yes. He took voluntary retirement and he contested the recently concluded elections.
Maybe he was scared of
Yes.
Aship.
It's hunting him.
So, now, but at that point of time, comparatively, in terms of promotion to the post of joint director, he was senior than the one who his corresponding
His equivalent, in the other
equivalent
way.
in the other way. That is my only statement.
Okay.
But only from the time this promotion was granted, they have brought out a separate seniority list. Otherwise, since we were never being promoted to a higher post, there was no scope of bringing out a separate seniority list earlier. So with regard to the post of additional director, your lordship, paragraph 9. Paragraph 9, if I may read. That it is pertinent to state herein that although there is no provision in the impugned service rules regarding additional director, the cabinet in its meeting held on 10/3/2005 approved one post of joint director to that of additional director in the Directorate of Employment and Craftsman Training. Accordingly, by notification dated number so and so dated 29/3/2005, one post of joint directors held by Shri S. Kevin was upgraded to that of additional director. And since then, the senior most joint director is being promoted to additional director since September 2020. The post of additional director is standing vacant due to the promotion of the incumbent to director with effect from 2/9/2020. Following the precedent, the petitioner number 1, by virtue of being the senior most joint director, now that was my contention, is entitled to be considered for promotion to additional director, but owing to objections from Shri Sabio Visa, Joint Director of the Employment Wing, who is junior to the petitioner number 1, the case of petitioner number 1 is not being considered. So that was the position at that point of time, at the time of filing of the writ petition. So an additional director's post was created, though it is not there in the service rules.
So it is just filling up
Yes,
the gaps.
Yes.
Filling up the gaps.
That was a thing. Then, Lordship, with regard to amendment, we submitted a representation, Your Lordship. That is at paragraph 10. Paragraph 10.
Paragraph 10.
Yes.
Your representation. Your
Yes,
representation.
My representation is.
No. Paragraph 10 speaks about your
Yes,
representation.
yes, my representation. Paragraph 10. partial amendment to the
Yes,
rules.
yes,
That was
yes.
my, yes.
Yes, Mr. Ongkok.
And paragraph 12, Your Lordship.
And?
Paragraph 10 is with regard to my representation
Yes.
only, so even if I don't read the
Ah.
paragraph, Your Lordship, paragraph 12, what happened was when our representation reached the government, the Honorable Chief Minister intervened in the matter and issued a memo saying that no amendments should be done and that since separate promotional avenues are there for both of them, it should be, the status quo should be maintained. That was stated 6/8/2021. Then what happened? This is a very important PNAR letter which was issued by the PNAR, paragraph 13. I'll read it and then I'll take
Paragraph,
your.
just wait, just wait. PNAR letter.
Yes, PNAR.
This is dated?
Letter dated 13/9/2021. 13/9/2021, which is at Annexure K, Your Lordship. Annexure K.
Yes, read it, please.
If I may read,
Yes.
I'll read the paragraph, Your
Yes,
Lordship,
yes.
and then that subsequently, the government by letter number so-and-so dated 13/9/2021 wrote to the director that the proposal for partial amendment of the imbued rules was sent to Personnel and Administrative Reforms Department for examination and necessary directives, and that the BNAR department has conveyed their examination as follows. We regret our inability to consider the proposed amendments to the existing provisions of the Nagaland Employment and Craftsmen Training Service and Nagaland Subordinate Employment and Craftsmen Training Service Rules 1988. Number two, the Employment Skill Development and Entrepreneurship Department, however, may examine the feasibility of bifurcating the training wing from the employment wing, given the fact that two wings are distinct from each other. Your Worship. So this is the observation. It's at Annexure K.
Annexure K, let's see that.
Yes. Annexure K. 106, page 106. Your Lordship. The last page.
Please read.
Yes, if I may. In inviting a reference to the subject cited above, I am to mention that a matter was processed by the department and the same was sent to Personnel and Administrative Reforms Department for examination and necessary directives. Accordingly, Personnel and Administrative Reforms Department has conveyed their examination as appended below via their UO number 492 dated 6/9/21. PNAR examination. Number one, we regret our inability to consider the proposed amendment to the existing provisions of the Nagaland Employment and Craftsmen Training Services and Nagaland Subordinate Employment and Craftsmen Training Services Rules.
This was
1998.
consequent to your representation?
Yes. Consequent to my representation. Then number two is very important, the second paragraph, Your Lordship.
Yes, wait. Yes, please.
The Employment, Skill Development and Entrepreneurship Department, however, may examine the feasibility of bifurcating the training wing from the employment wing, given the fact the aforesaid two wings are distinct from each other. That was the observation for bifurcation. Now, bifurcation, process was made in the Secretariat. Now, this Honorable Court also asked the learned government advocate to see the status of the process that is going on in the secretariat. They have filed an affidavit. The affidavit.
This is Ms. Sokre. Any steps taken for bifurcating these two wings?
Lordship, I have filed my affidavit stating that till now the government has not given any outcome on that issue.
Yes.
Yes.
Now this is off the record, Your Lordship, but the position is like this. It's off the record. There will be no bifurcation because the employment wing is deadly against it internally. That is the position. Now what happens is most of the funds with regard to the two wings, with regard to central funds, the maximum amount comes from the training wing. So obviously, if bifurcation is done, then the other wing buckets will be emptied. So now they are deadly against the bifurcation, and since we are we are at a disadvantage, we cannot do anything. But all the influences are there from the other, and this is off the record. But this is the position, Your Lordship. So the question of bifurcation does not arise. So the position is that they want to enjoy all the promotional avenues, subordinating us. That is the position, Your Lordship.
your
We are
funds.
in, and
And
my
your funds as well.
and our funds as well. That is my position. It's off the record, but that is the factual position internally. What that is going
Sir
on.
Shipre, you're becoming very selfish.
That's exactly what is going on.
My lord, that may not be correct. My brother said that is off the record. So
Yes, it is off the record.
Yeah,
Yes.
I am also giving this opinion off the record.
Yes. It is off the record only. Your Lordship. No serious allegations, but then, so we have been from the very beginning disadvantaged, and during the disadvantage period, even these service rules was prepared, Your Lordship. So obviously, the outcome is there plainly to see. So now, Your Lordship, I'll just take your Lordship to my affidavits in replies to the affidavit in reply to the government. Your Lordship,
You have still not met your main submission.
Your Lordship,
As to why
this is a
this
factual
court should
position,
interfere
and
with
then
the
now
service rules.
I'll take Your Lordship to the judgment, to two judgments only.
No.
And
Before
then-
that, we want you to actually satisfy this court as
I
to
will-
why this court should interfere with the rules.
Your Lordship, my humble submission is that we are, as per Rule 3, it is plainly shown that these two wings are separate, but the number of the posts hierarchy is same in both. The hierarchy of the post is same in both.
See,
So
Mr.
now no distinction can be drawn
Tongpa.
between this or that.
By not giving you promotion to the post of director,
Yes,
correct?
yes.
There may be heartburn for the training wing. There may be heartburn. But at the same
Yes,
time,
yes.
you will have to satisfy this court
There must
why
be-
we should
yes.
interfere with the rules.
I'll take Your Lordship to the judgments so that the judgments are very clear. Article 14, there must be clear, intelligible differential between the two to discriminate.
That is between the same class. You are not
They
same
are
class.
in the same class, Your Lordship.
The PNAR itself has said that you
They
are
are
distinct
different,
class.
yes. But then when it comes to promotion, for example, yes, at least both should also be given.
Okay, let's
That
see
is
your
my only
affidavit in
case, Your
reply.
Lordship. If Your Lordship is not satisfied, what more can I
No.
say?
It's
That
not
is
a
my
question
only
that we are
case.
not satisfied.
Yes.
We want you to satisfy
Yes,
us. We want you to satisfy us.
Whatever I have, I will give it to Your Lordships. That is the only case I am having. If Your Lordships are not satisfied, what more beyond that? What more can I do, Your Lordship?
Mr. Tongpok, you are actually challenging the rules.
Yes, Your Lordship.
It is not for us to be satisfied. It is
Your
for you to
Lordship.
satisfy us.
That is why, yes, I am trying to satisfy Your Lordships But if my submissions are not satisfactory, then
Okay, you want to read your
Yes,
affidavit in
Your
reply?
Lordship.
Let's see.
Since much time has gone by since I have stood up, I'll just go to the government's affidavit where.
No, your affidavit in reply?
Yes, affidavit in reply that.
You are referring to which? Your affidavit or?
My affidavit in reply to respondents number 1 to 4. Affidavit of respondent number 1 to 4.
To R 1 to 4.
Yes. The main.
Yes.
The main paragraph is at paragraph 4, Your Lordship, because this is the paragraph 2 is one statement. Paragraph 2 also, Your Lordship. Paragraph 2 from paragraph 2 I made it, Your Lordship. That with regard to the statement made in paragraph 5 of the affidavit in opposition, the deponent respectfully states that a perusal of the memorandum dated 1986 on the final seniority list in respect of gazetted officers in the employment department as on 1/1/1985 relied upon by the respondents reveals that Shri Kibi Sozoli Suhor was holding the post of joint director but confirmed as deputy director only. Therefore, he was holding the post of joint director T. Horst the rules. Hence, the said seniority list only validates the statement of the petitioner's statements in paragraph 5 of the petition.
See, Mr. Tongpo, my
Yes.
view is that, our view, sorry,
Yes.
is that when you have not challenged the seniority list, you should have no grievance to the seniority list.
I am not challenging,
not
but they are trying to justify, they are trying to show that my statement, they are trying, in their affidavit, they are trying to show that, to controvert my statement in my petition that at that point of time when merger was done, the 1984 rules was in place. And as per the 1984 rules, only one post of deputy director was available for the employment wing at that point of time, at the time of merger. That is my statement. Only one post of, as per the service rules.
That is a past story.
That is a past story, but they have made a big issue out of in their paragraph 2. That is why I'm just replying that. It was T. Horst the rule. When promotion may have been granted, but if the rules does not show it, then it does not help them. That is what I'm just saying.
No, what was the rules?
The rules only had one post of deputy director, as per the rules. So the question of when there is no post of created post for them in the higher category, promoting them. Yes, they were promoted, but that does not mean that it is in accordance with the rules because there was no post available at that point of time. That is what I'm just saying. They have been doing that. They have been doing that. I'm not aggrieved. I'm not aggrieved. Yes, there is a filling up of gaps in between by the government. I'm not aggrieved by that. But what I'm trying to project before this honorable court was that at the time when merger was done, they had only one post of deputy director.
Okay.
And then immediately upon merger, one post of deputy director was created for us. Equivalency, Your Lordship. But subsequent to that, after that also, even though the post was created for us, we were not promoted. All these vacancies were filled up by them. We did not challenge it. We are not aggrieved by that. But I am just projecting the facts, the history. Projecting the history of the case, how these things happened, and so because they were in the dominant position, far above us, the service rules was made by them. And so the service rules has come out like this. And my submission before this honorable court would be that if there is clear distinction between me and them, then it should be also be as to why only they should have these kind of privileges should also be clearly reflected in the service rules, Your Lordship. Because the service rules will speak. Without the service rules laying down clear criteria, differentiating the two of us, neither me nor nor the respondents nor this honorable court can arrive at a decision.
When you say that actually these two are two distinct wings.
Yes.
These two are two distinct
Yes.
wings. when you are of that view, we cannot make any comparison. You will have to stand on your own feet.
Your Lordship.
You cannot make a comparison with them.
No, Your Lordship, on the basis of the Rules 3. If Your Lordship is saying that Rules 3 is not applicable, then
No, I am not saying that.
I have no case.
But
Your
when
Lordship.
actually the two services are distinct and separate. Two services are distinct and separate.
Yes.
So when you say that, and when actually the two services are distinct and separate, to claim some right for you, you cannot make a comparison with them. You have to stand on your own feet. You
Yes.
have to expose your own cause.
Your Lordship.
And you have to actually satisfy this code as to why you should not be granted that benefit.
Your
have to
Lordship,
stand on your own
then my case is that I should also, if that is the case, then since we are two wings, then they should not insubordinate us. That is my case. They should not insubordinate us.
See, they are distinct.
Ours is
So
also
question of
distinct, so-
insubordination doesn't come.
No, the director's post. There's only one post of director. If there were two posts of director, one for both the wings, then there would be no case for me. There would be no case at all for me. But there is one post of director, which is the head, and it is going to
And
take
that post
care
of
both-
director is
both the
from the
wings.
employment wing.
Yes, now that is where
So
I am
that is in
agreed.
the wisdom of the government.
Your Lordship, the wisdom of the government must be supported by clear-cut criteria laid down by the government itself. It should clearly lay down the criteria as to why they are doing this. It is not there in the service rules. That is my case, Your Lordship.
Maybe.
It has to be there, but even filing
while
of
examining a challenge to the service rules, maybe this court will not go to that extent.
no, Your Lordship, it has to be there because equality says that unless there is intelligible criteria, intelligible differential, clear reasons.
Classification is for the same class of persons. You're from different class.
No, we are from two distinct groups, but classes are same, Your Lordship. That is my case. The classes of posts which we are holding are same. That is my case, Your Lordship. The class of posts. Yes, wings are different, but the posts, class, we hold the same class of posts, the two of us. That is my only case, Your Lordship. Beyond that, I don't have any other case, Your Lordship. Honestly speaking.
Okay.
That is my only
Let's
case.
come to your
Yes.
affidavit in reply.
Paragraph 4.
Para 4.
Yes.
Yes.
That with regard to the statements made in paragraph 7 of the affidavit in opposition, the deponent respectfully states that from the rule 3 of the imbued service rules, incontrovertible inference can be drawn that the two wings are co-equal. The constitution of service provided in the rule 3 plainly lays down in minute details the equivalency of posts of various categories between the two wings, with neither of the two being projected as superior to the other. Therefore, it would be absurd to argue that unless there is specific language declaring the two wings as co-equal, the two wings cannot be equated. No inference other than co-equality of the two wings can be drawn from the plain reading of Rule 3. The statement of the respondents that there is no common seniority list maintained in the department is not disputed. Without it being said, the scheme of the said rules itself necessitates maintenance of separate seniority lists for the two wings. It is not the case of the petitioners that a common seniority list is being maintained for the two wings. What the petitioners are aggrieved with is the arbitrary and discriminatory provisions of the impugned service rules, particularly the Schedule 1A, 1B, and 2B, which makes provisions of unequal distribution of posts between the two wings and inequality in promotional avenue that prevents a joint director of the training wing from promotion to additional director and to director without any rhyme or reason. As regards the Department of Personnel and Administrative Reforms, letter dated 13/9/2021 concerning examination of feasibility for bifurcation of the two wings, the same is merely a suggestion, and so long as the two wings remain unbifurcated, there must be variety of opportunity for both the wings. Further, with regard to the statement that since the service rules provides for the constitution of service, strength of service, and method of recruitment for both the wings, it cannot be said that equals are being treated unequally since both the wings have separate promotional avenues as well as separate seniority lists. The respondent respectfully states that such statement is without foundation. There is no rational basis to make the training wing subordinate to the employment wing on the pretext of maintaining separate promotional avenues and seniority lists. When both the wings are equally circumstanced, as in the case here, there must be equal distribution of both in the higher echelons of the service and equal opportunity of promotion up to the apex level for both the wings. At the entry grade, both the wings are equivalent. In this regard, it is pertinent to note that there are two feeder grades for both the wings, namely technical assistant and employment officer for the employment wing, and trade instructor and vice principal for the training wing. The post of technical assistant of the employment wing is equivalent to the post of training instructor of the training wing, and the post of employment officer is equivalent to the post of vice principal. Whereas, while the next post of promotion for the technical assistant is the post of employment officer, for the training instructor to reach the post of vice principal, which is a post equivalent to employment officer, they have to pass through two promotional posts, namely senior instructor and foreman, related instructor, group instructor. And while there are 90 designated posts of trade instructors, there are only 8 posts designated posts of technical assistant. The inequality between the two wings, however, starts at the level of deputy director and upward. Schedule 1A provides for 4 posts of deputy director, 1 designated as regional employment officer, 1 post of joint director, and 1 post of director for the employment wing. On the other hand, Schedule 1P provides for 2 posts of deputy director, 1 designated as senior principal only for the training wing. And even here, in reality, only 1 post of deputy director is made available to the wing, as none so far has been promoted to principal senior grade. In other words, the post of principal senior grade remains only in the service rules. Whereas in respect of the employment wing, the horse the rules, the post of joint director was upgraded to additional director. And with such upgradation, 1 post of deputy director was upgraded to joint director. And yet, the respondents claim that there is perfect justice without citing any cogent reasons as to why there is so much inequality between the two wings. Not only are the impugned rules utterly arbitrary, unreasonable, and discriminatory, but even outside the scope of the service rules. The respondents have been acting arbitrarily, unreasonably, and discriminatorily in extending further advantages to the employment wing by upgrading the post of joint director to additional director and upgrading 1 post of deputy director to joint director. So their stand is that yes, they are two distinct wings. That is what they are saying. So there is no discrimination, even though we don't grant them the promotional avenues. That is the state government's primary stand in the affidavit. So this is my reply to the affidavit. Yes. Your Lordship, my affidavit in reply to the affidavit in opposition of the respondent number 5 to 16, Your Lordship.
Respondent number?
Private respondents, 5 to 16. 5 to 16.
5 to
16.
60.
16, 1 6, 1 6, Your Lordship. Their statement in the affidavit is that with regard to the training wing, only where there are 3,000 to 7,000 seats, sitting capacity, no post of joint director can be created. That is their stand. But it is as per the central manual of the craftsman training. But that is not the case. The central manual nowhere says that. So I have made my reply in paragraph 5, Your Lordship. Paragraph 5, I'll read through 2 paragraphs, main paragraphs, Your Lordship. Paragraph 5, 14.
5?
5 and 14, Your Lordship. Paragraph 5 and 14.
Yes.
That, if I may read, that with regard to the statement made in paragraph 2F of the affidavit in opposition, firstly, the preface to the training manual for industrial training institutes specifically declares that the manual is not a legal document. but is made only to serve the users for smooth implementations of the norms prescribed by the National Council for Vocational Training, NCVT. Secondly, the manual nowhere provides that for implementation of craftsman training scheme, the post of joint director can only be created if there are more than 3,000 to 7,000 seats for the trainees. And the post of deputy director can be created if there are more than 2,000 to 4,000 seats for trainees. This is their statement, but the manual nowhere says so. The figures projected by the respondents are merely figments of their imagination. In fact, the manual provides that a post of training and placement officer in the rank of deputy director, joint director be created in an ITI having 1,000 or more sanctioned seats. And it is to be seen that this criterion is fulfilled in respect of Nagaland. Yet, considering that the manual is not a legal document, it is not a legal document, it is irrelevant to dwell on this aspect.
Let us see once more this. In fact, the manual provides that a post of training and placement officer
Yes.
in the rank of deputy director / joint director
Be created in an
ITI having
having
10,000 or more sanctioned
seats.
seats.
Yes.
And it is to be seen that this criterion is fulfilled
Yes.
in respect of
Nagaland.
Nagaland.
Yes. But then in a manual is, since it is not a legal document, it is irrelevant to dwell on that aspect. But they are making a point on this aspect. That is why I am just clarifying it. Since the manual is not a legal document, even the manual declares it, that it is not a legal document. It is only there for the smooth implementation. Thirdly, the functioning and, if I may continue, Your Lordship. Yet, considering that the manual is not a legal document, it is irrelevant to dwell on this aspect. Thirdly, the functioning and staffing pattern of the employment wing is also not in accordance with the guidelines laid down in the National Employment Service Manual. And apart from that, the manual prescribes that there will be a state employment exchange at the headquarters of the state with one state employment officer, assistant director, only one assistant director, one regional employment officer, professional and executive, one regional employment officer, ex-serviceman, so-and-so, etc. The imbued rules in respect of the employment wing clearly contradicts the national manual in that the national manual does not prescribe any post of joint director and deputy director, but one post of assistant director designated as state employment officer, whereas the imbued rules makes provisions for one post of joint director, 4 posts of deputy director, one such post designated as regional employment officer, which according to the national manual is not even equivalent to assistant director, and the post of district employment officer as equivalent to assistant director, which the national manual nowhere contemplates. Hence, the stand taken by the respondents is without foundation and mere contrivance on their part. On the other hand, the rules and the record amply reflect clear discrimination against the training wing. So, even in their case, it is not in accordance with the national manual.
In your case too?
In my case also. But they are making it a case against me. That is why I'm just highlighting this.
So don't make a case against one
No,
another.
yes. So they are going to raise it. This is why I am. Since they will be making a stand on it, that is why I have made that reply in detail. The manuals, they are not legal documents, in fact, both in both the cases. These are just made for the sake of
Guidelines.
Yeah, guidelines. These are just guidelines, and they are not enforceable. And in their case, the guidelines have not been followed. Whereas they are saying that in my case, guideline has not been followed.
No.
That is what they are saying.
You have also been given the post of joint director.
This is why, Your Lordship, they are saying that in my case, guideline has not been followed. Whereas they are, in their case also, the guideline has not been followed, but they have not highlighted it. This is why I'm just highlighting it before this honorable. I have nothing against that, but they will be raising this issue and trying to lead the court into a rabbit trail.
See,
So,
Mr.
in
Tumbo,
order to
now what,
do away with that.
what we are understanding is
yes.
that you have no grievance against the post of director, additional director, joint director
Yes.
in the
Yes.
employment wing. You have no grievance.
Yes, only that.
Your only grievance is that this post should also be created in your wing.
If not, from the post of joint director above, we should also be given equal opportunity to be considered for promotion
In that case,
That is my only
you will be
case.
an encroacher.
No, Your Lordship.
You will be encroaching upon the post of the employment wing.
Your Lordship, no. Because nowhere in the Rule 3 does it specify that the post of director is the post under Rule 3. Post of the two wings come up like this. And then
if you read the schedule
this is
itself,
why I am challenging the schedule.
itself says that you are two different class.
This is why I'm challenging the schedule with regard to promotion. If your Lordship feels that they have a right to insubordinate us, what more can I say?
When you are making a submission saying that actually your grievance is only with regard to non-creation of the post of director or for that matter, additional director, then creating this additional director post in the employment wing should not grievance you. You should not take that for offense.
Your Lordship, if your Lordship feels that it is, your Lordship can always, considering the nature of the case, can always mold the relief accordingly.
No, but
since I am challenging inequality in the schedules, make it equal for both parties.
Molding relief does not give us the power to actually amend or to tinker with the rules.
If your
Molding
Lordship,
the relief
yes, your Lordship, if your
will
Lordship
not
finds,
go to that extent.
if your Lordship finds that, if your Lordship finds out that inequality is apparent for the two wings, then a direction may be given that this inequality should be rectified. Your Lordship, that is more than that is enough.
The question is, how can we make that comparison?
Your Lordship, I will make my submissions since decision is to be taken by your Lordships.
No,
I will leave
we
it
take
with your
decision,
Lordships.
But you will have to satisfy us. It is your case. You will have to satisfy us.
Then your Lordship, allow me some time for further examination of further research in some judgments, your Lordship. But I'll have to show your Lordship the two judgments. But if your Lordship feels that I have to.
No, you have to. Of course, that is a law.
Yes.
You will have to satisfy this court.
This is why.
You cannot actually stand on the case of the government or for that matter, the private respondents. You will have to stand on your own case.
Yes, I am trying
and
to.
accordingly, you will have to
Yes.
bring citations.
I am trying to show
Which
your
shows
Lordship.
that actually you are discriminated without actually comparing, without dragging in the private respondents and the state. You will have to show.
Your Lordship, I am laying out the facts before your Lordship.
No, facts
I am laying out before your Lordship.
We are now understanding.
Now, yes.
That is why we are raising all these issues.
I know, yes. I am laying out all the facts, and then I'll try to analogize my stand with a judgment of the Supreme Court, Honorable Supreme Court. If your Lordship is not satisfied with that, what more can I say? Your Lordships.
I believe that you are actually trying to bring some judgment on this classification.
Yes.
Without any intelligible.
Yes.
I think maybe, of course, I don't know, but to my mind, I think that may not be very relevant.
Your Lordship,
When you are admitting
if it is not
that you are two different class, the classification cannot be for unequals.
when it comes to wings, we are different wings. But when it comes to the posts, there is equivalent posts. That is my only case. My only case is that there is equivalency in the posts. So they should be equally treated when it comes to promotion to the higher post. That is my only case, Your Lordship. I have no other case. It is shown if your Lordship is not satisfied,
That
what more
point
can I
we
say?
will see when the
Yes.
learned additional advocate general will submit the affidavit explaining the nature of your work.
Otherwise, everything is on record.
No,
in the minute.
everything is not on record.
No,
That manual,
yes.
not no.
The functions, everything is here. So the one which I was submitting.
That is the manual. See, we want you to explain. We want you to explain. Ms. Sokre, don't take
Oh,
shortcut.
Lordship.
If they have to file the affidavit, then I'll have to be given the opportunity to reply also, Your Lordships.
Yes.
So that is my position is only this, Your Lordship. I cannot, I'm not going beyond that. Very limited. My ground is, my position is very limited. Only on that aspect, I am before this honorable court. I am not adding anything extra beyond that. When both of us are shown to be having equivalent posts, then when it comes to promotional avenue also, at least equality should be given to both. That is my only case. And paragraph 14, Your Lordship, paragraph 14, that I have already taken Your Lordships to in the earlier with regard to the number of posts assigned to each. So, employment wing, the total number of posts under the employment wing, the total number of posts under the training wing. So, obviously, we have more number of employees. The number of employees in the training wing is more than the number of employments in the Your Lordship, I'll take Your Lordship to the, like Your Lordship has rightly pointed out, with regard to classification, with regard to reasonable classification, Your Lordship. Since me trying to explain it in my own way may not be.
Not in your own way, Mr. Tongpo, what
Yes,
the
Your
law
Lordship,
says. Yes.
This is 2015, then Supreme Court cases 681.
2015,
10 SEC,
10
681.
SCC, 10 SCC, page
10 SEC 681.
681. Para?
Yes. Para 13 to 16, Your Lordship.
Para 13
Yes,
to
para 13
16.
to 16, yes. This is only with regard to Article 14.
Yes.
Yes.
Para 13.
Para 13, Your
Yes,
Lordship,
yes,
page
yes.
694.
6. Yes.
If I may read, Your Lordship, it is thus beyond any veil of doubt that the justiciability of particular notification can be tested on the touchstone of Article 14 of the Constitution. Article 14, which is treated as basic features of the Constitution, ensures equality before the law or equal protection of law. Equal protections means the right to equal treatment in similar circumstances, both in the privileges conferred and in the liabilities imposed. Therefore, if the two persons or two sets of persons are similarly situated, placed, they have to be treated equally. At the same time, the principles of equality does not mean that every law must have universal application for all persons who are not by nature, attainment, or circumstances in the same position. It would mean that the state has the power to classify persons for legitimate purposes. The legislature is competent to exercise its discretion and make classification. Thus, every classification is in some degree likely to produce some inequality as violated only, but mere production of inequality is not enough. Article 14 would be treated as violated only when equal protection is denied, even when the two persons belong to same class category. Your Lordship. Category, Your Lordship. Class or category. That is my statement. We are in the same category.
No, you are not.
Same, Your Lordship.
You are not.
No, post-wise that
You
we are
are-
holding. We
you
are in
are
the
in
same
different
category.
wings.
We have been classified into two wings. Yes.
You are in
But
different streams.
the two streams, they are they are
Okay.
there's equality in it.
Yes.
Protection is denied even when two persons belonging to same class category. Therefore, the person challenging the act of the state as violative of Article 14 has to show that there is no reasonable basis for the differentiation between the two classes created by the state. Article 14 prohibits class legislation and not reasonable classification. That is position. What follows from the above is that in order to pass the test of permissible classification, two conditions must be fulfilled. Namely, one, that the classification must be founded on an intelligible differentia which distinguishes persons or things that are grouped together from others left out of the group. Yes, this is one position. Number two, that differentia must have a rational relation to the object sought to be achieved. The object sought to be achieved. There must be a
between the same class.
there must be a
Between the
by
same
the statute
class.
in question. If the government fails to support its action of classification on the touchstone of the principle, whether the classification is reasonable, having an intelligible, if the government fails to support its action of classification on the touchstone of the principle, whether the classification is reasonable, having an intelligible differentia and a rational basis, germane to the purpose. Germane to the purpose, Your Lordship. Now, promotion for the post of director, Your Lordship. All being equal below the post of director, Your Lordship. Only to the post of director. There must be clear-cut criteria laid down showing that only this group is entitled. Why? That reason should clearly be there. And it is for the government to satisfy this honorable court that this group is being preferred because they have this apart from this group. This has not been shown in the service rules, Your Lordship. This is my only case. Now, Your Lordship, I'll take Your Lordship to that Supreme Court case, which Your Lordship may have been. This may be the case.
Mr. Sokre, whether you have the aims and objects of the framing the service rules, aims and objects.
Yes, Lordship, it's very clear.
Aims and objects.
Lordship say, the training wings, they are the institutional. They are the industrial training institute. And, and they were brought within the administrative control of the employment exchange. Then after they were brought into the employment exchange, the employment exchange service rule was amended and they were included into the wings. And Your Lordship, the employment, the Department of Skill Development and Entrepreneurship, it falls under the concurrent list. So even the guidelines that was given by the ministry has to be followed by the state. So Your Lordship, as per the ministry guidelines, the manuals, Your Lordship, on the last occasion also, Lordship, I have placed before Your Lordship.
No. I am asking you just a simple question. Whether there is any aims and objects behind the framing of the service rules.
Your Lordship, everything the manuals has been taken into consideration.
Yes.
That's why they have framed this rule. That's why they were separated and not to reach to the point of a director because of the manuals, Your Lordship.
Yes.
Yes, Your Lordship, the second case, this may be the same one which Your Lordship may have been referring. But I'll take Your Lordship through it.
Is it 1973?
It is 1974.
Constitutional bench.
But this is SCC. Yeah, but the bench of Justice Chandrachud, then. Oh, yes. 4 of them, Your Lordship. Before A.N. Ray, CJ, and D.G. Palikar, V.Y. Chandrachud, P.N. Pakwadi, and V.R. Krishna Iyer. CJ. It's a full bench. You know, this may be the case which Your Lordship may have been. But this is the SCC. Because of that, the year may be slightly different. Sometimes that which is reported in the AIR in 73 gets reported only in 74 also. I'll take Your Lordship to para 29 to 34 and 39 to 49.
29?
29 to 34.
1974 1. Para
29 to 34 and
29 to 34 and
39 to 49, Your Lordship.
39 to 49.
Yes. Yes.
Okay.
Two sides of the coin have been discussed in this. This is why I am first from 29, Your Worship. This is classification on the basis of educational qualification. 29, yes. This argument as presented is attractive. Para 29, Your Worship. As presented is attractive, but it assumes in the court a right of scrutiny, somewhat wider than is generally recognized. Article 16 of the Constitution, which ensures to all citizens equality of opportunity in matters relating to employment, is but an instance or incidence of the guarantee of equality contained in Article 14. The concept of equal opportunity undoubtedly permeates the whole spectrum of an individual employment, from appointment through promotion and termination to the payment of gratuity and pension. But the concept of equality has an inherent limitation arising from the very nature of the constitutional guarantee. Equality is for equals, that is to say, those who are similarly circumstanced are entitled to an equal treatment. Here we are similarly circumstanced, Your Lordship. Since the Constitutional Code of Equality and Equal Opportunity is a character for equals, equality of opportunity in matters of promotion means an equal promotional opportunity for persons who fall substantially within the same class. A classification of employees can therefore be made for first identifying and then distinguishing members of one class from those of another. Classification, however, is fraught with the danger that it may produce artificial inequalities. And therefore, the right to classify is hedged in with salient restraints, or else the guarantee of equality will be submerged in class legislation masquerading as laws meant to govern well-marked classes characterized by different and distinct attainments. Classifications, therefore, must be truly founded on substantial differences which distinguish persons grouped together from those left out of the group, and such differential attributes must bear a just and rational relation to the object sought to be achieved. 32. Judicial scrutiny can therefore extend only to the consideration whether the classification rests on a reasonable basis and whether it bears nexus with the object in view. It cannot extend to embarking upon a nice or mathematical evaluation of the basis of classification, for where such an inquiry permissible, it would be open to the courts to substitute their own judgment for that of the legislature or the rule-making authority on the need to classify or the desirability of achieving a particular object. Judged from this point of view, it seems to us impossible to accept the respondent's submission that the classification of assistant engineer into degree holders and diploma holders rests on any unreal or unreasonable basis. The classification, according to the appellants, was made with a view to achieving administrative efficiency in the engineering service. If this be the object, the classification is clearly correlated to it, for higher educational qualifications are at least presumptive evidence of a higher mental equipment. This is not to suggest that administrative efficiency can be achieved only through the medium of those possessing comparatively higher educational qualifications, but that is besides the point. What is relevant is that the object to be achieved here is not a mere pretense for an indiscriminate imposition of inequalities, and the classification cannot be characterized as arbitrary or absurd. That is the farthest that judicial scrutiny can extend. 34. On the fact of the case, classification on the basis of educational qualifications made with a view to achieving administrative efficiency cannot be said to rest on any fortuitous circumstances, and one has always to bear in mind the facts and circumstances of the case in order to judge the validity of a classification. The provision in the 1939 rules restricting direct recruitment of assistant engineers to engineering graduates, the dearth of graduates in times past, and their copious flow in times present are all matters which can legitimately enter the judgment of the rule-making authority. In the light of these facts, that judgment cannot be assailed as capricious or fanciful. Efficiency, which comes in the trail of higher mental equipment, can reasonably be attempted to be achieved by restricting promotional opportunities to those possessing higher educational qualifications. And we are concerned with the reasonableness of the classification, not with the precise accuracy of the decision to classify, nor with the question whether the classification is scientific. Such tests have long since been discarded. In fact, American decisions have gone as far as saying that classification would offend against the 14th Amendment of the American Constitution only if it is purely arbitrary, oppressive, or capricious. And the inequality produced in order to encounter the challenge of the Constitution must be actually and palpably unreasonably and arbitrary.
What do you want to convey? What do you want to convey by reading
Here,
this?
by saying that, yes, if there is a clear standard shown that these two groups are not similar to this group, there must be some clear distinction between the two. That is what the Supreme Court has said. Similarly
Is there not
situated.
distinction in your case?
In our case, there is no distinction. Only that, the only distinction is that we come from two different wings. The only distinction.
And the case
But
referred by you is classification on the basis of
educational qualification. There is no distinction in educational qualification between us, Your Lordship. There is no educational
Okay,
distinction.
any other
Now,
citations?
paragraph 39, 30,
Yes, I have gone through this judgment.
Your Lordship.
Lastly, no promotion was allowed. There
In
is
this-
a case where
in
assistant
your case, there
engineer
were-
was
yes.
claiming promotion, saying that he has no scope for promotion.
In their case, they challenge the service rules on the basis of, yes, and that the service rules. with
In your
regard
case
to
also,
this
you are challenging the
classification.
service rule, saying
Yes.
that there is no scope for you to be
But
promoted.
here, that
Here also same.
Your Lordship, similarly situated, Your Lordship. Not exactly equally situated, but similarly situated, Your Lordship. My case is we are similarly situated. What is the distinction between us? That is the only, that is
That's
my
why
only stand.
we are
Yes.
telling the government to file
Yes.
affidavit.
So,
we want to.
so if
what
we
is the
are,
distinction?
yes, if they can show it from the service rules, then well and good. We have no case at all. But the service rules is silent on it.
Let them file an affidavit stating.
And just merely making some, throwing out some statement that because they are employment wing, so they should be administrative, it is no ground, Your
See, the
Lordship.
service
Yes.
rule will not enlighten us on all this, that this group is doing this group is doing this nature of work. Service rule will never say that. Service rule will never say that.
It will have to clearly
So,
specify.
it does not mean
It
that
must-
we
it
are
must
allowing
give
the
the reasons.
government to file affidavit.
Your Lordship, then,
We will be just carried away like that.
then Your Lordship, instead of going any further, if the government may be
Yes.
asked to meet.
We will list it on Monday.
I have a difficulty on Monday, Your Lordship. Next week and after that, Your Lordship, I have difficulty, Your Lordship.
Wednesday, Your Lordship,
Yes,
same,
no.
same hearing
Because,
day.
Lordship, I'll be going to the principal seat next week, Lordship. So I don't know when. I don't know when I will return, Lordship.
When, if
Otherwise, Your
it is
Lordship,
not
the
possible
manual,
for her.
everything what I was submitting, that
Ms.
is very
Sokre,
same in.
please minus your manual, you make your
Yes.
submit. You can file your affidavit on Monday. You can Saturday, Friday, Saturday, you can file it and then
Give me also a copy so that I may,
yes,
if
we can
necessary, I can also counter it, Your Lordship.
just filing one affidavit to make two paragraphs that the employment wing is involved in this nature of work, that the craftsman wing is involved in this nature of work. That I think you are such an experienced lawyer, that will not take you any time. So you list on Friday, you give it. Monday we'll list it.
No, Your Lordship,
On Monday, I won't
make
be-
it Wednesday, Your Lordship,
Yes,
make
I
it
won't be
Wednesday.
here.
On
Even
Monday,
on
I have a small,
Wednesday also I have a
Yes.
problem. I don't know
Wednesday
when.
you may not get your chance because
Yes.
there are some other cases.
it may be, since my part has been heard, Your Lordship, so no need for me to keep on harping over the same thing over and over again, Your Lordship.
So we'll list it on Monday.
Your Lordship, on Monday, I have made an appointment. And it would be difficult for me to back out of that. They have allotted me that. So if maybe Tuesday,
Tuesday also, Your Lordship, I can. Next week I cannot be available, Your Lordship.
We will hear you when you come. We will hear you when you come. He is almost finished.
Okay.
We want your affidavit.
Lordship. In that case,
And
I
then
can file.
we will
Yes.
let Mr. Ashipre continue.
Mm.
And then we will hear you when you are there.
Okay.
Need not be on Wednesday, maybe on the last part, last week, Monday.
Otherwise, Your Lordship, for 2 weeks, I may be engaged.
Third week, Monday, we'll make it.
Okay.
Third week, Monday. We'll accommodate you. We'll hear you.
So next Monday?
Since you have already exhausted so much of our time, we are intent to actually complete this
Yes.
hearing. So you file your affidavit by Friday? Okay? Or even if you're not there, if you complete your affidavit, then you can interest some of your juniors?
Yes. Lordship.
Okay? So that next week when it is listed, though you are not there, we just want to see your affidavit. And please make it detailed.
Yes.
Okay?
Wednesday, Your Lordship, or Tuesday?
Yes, Mr. Ashipre, Wednesday or Tuesday. 2 days continuous.
My lord, Wednesday, practically not possible because we have seen so many cases fixed on Wednesday.
Wednesday, first item, shall we?
No problem for me.
Your Lordship.
Wednesday, item 1.
Your Lordship.
Okay.
For me, I'll hardly
Since it
take
is
30 minutes.
already part third, if it may be made.
You
I
come
don't
with helmet and all because
Yes.
our senior city Jamir and senior Iralu will be there. So you come with helmet because you will be occupying their slot.
My lord, since this is part hard, very kind of this court for accommodating us.
Heard Mr. Pongpok, Pongoner, the learned counsel for the petitioner, and Ms. M.S. V. Sokre, the learned additional advocate general, Nagaland, and also Mr. Azo, learned counsel for the respondent number
5 to 16.
5 to 16. The hearing remains unconcluded, listed again on
Wednesday.
on 24th.
24.
My lord, 24.
On 24/5/2023 as the first item. Stop. Or MSV Sokre shall file MSV Sokre, the learned additional advocate general, shall file a detailed affidavit stating the nature of work. Where is that service rule? Stating the nature of work.
For the employment wing as well as training wing.
Yes. Under what department is this?
Employment and craftsman training services, Your Lordship. Employment and craftsman training.
Stating in detail, the nature of works performed by the employment wing and the craftsman training wing.
Yes.
Under the Nagaland Employment and Craftsman Training
Services.
Under the Nagaland Employment and Craftsman Training Service.
Yes. Directorate, or will also be that. It's a directorate, Your Lordship. So if it is made directorate, it is okay.
Directorate of, under the
Yes.
under the Directorate of
Employment and craftsman training services. Oh, employment, skill development and entrepreneurship.
under the Directorate of Employment, Skill Development, and Entrepreneurship. Okay. Kohima, Nagaland, Kohima. The affidavit shall be filed on or before, what is Friday? 19/5/2023. Ms. Sokre, please actually file a detailed statement about the nature of the works. Okay, we want to know because your friend Mr. Tongpok is banging so much on classification.
Yes.
So whether there is a classification or not, we can actually
Yes.
know something from the nature of the work.
Yes.
Okay. Okay. We have given a date.
Yes, yes.
Yes, okay.
Item 30 and 31. Read Appeal 27, 2022 and WPC 71, 2022.
Your Lordship, in item 30, my colleague, learned colleague, Inti Launcher has made a mention.
He has mentioned?
Yes, item 30, yes. But for item 31,
You were saying about listing it before the single bench?
Yes, Your Lordship.
Yes, Ms. Sokre.
yes,
Well,
it has to be before the single bench, Your Lordship.
is it? What is the nature of the case?
It's about worker regularization. So the matter is a single bench matter.
Okay.
But on the last occasion, the single bench and the division bench pending cases had to be clubbed together. Maybe because of that, it was listed today.
Okay, it is submitted by the learned counsel for the parties. But this is a single bench matter. And therefore, the case should be listed before the appropriate bench. Stop, list the case before the learned single bench.
Much black.